Okay, I have 9 o'clock on my watch. We're going to go ahead and get started. We have a packed program, so thank you for joining us this morning for our 5th annual half-day CLE on significant developments in consumer financial services litigation and enforcement. My name is Ryan D. Clemente, and I'm the co-chair of Saul Ewing's Consumer Financial Services Litigation Practice. We have a really great program scheduled for today. We're going to begin with Trip Riley and John Redding of Alston and Bird for a regulatory update to discuss some really interesting issues that are going on with regulatory enforcement. Next, we have a roundtable discussion scheduled with a number of terrific in-house counsel speakers discussing some recent trends in arbitrations, including mass arbitrations. And then we're going to follow that with discussions on FCRA litigation, and we'll complete the program with an update on developments in class action litigation. Before we begin, there are just a few housekeeping announcements. Questions can be submitted through the Q&A tool at the bottom of your screen. And while we're going to do our best to answer all of your questions, should we run out of time, we'll follow up individually via email after the program. For CLE credits, today's program has been approved for 3 distance learning CLE credits in Delaware, Florida, Illinois, New Jersey, New York, Pennsylvania, and with applications pending in Minnesota, Virginia, and Ohio. As the CLE provider, we have to be able to verify your attendance. So at random points during the webinar, we're going to display and verbally announce 3 numeric reporting codes that you must record and report back to us using the CLE survey that you received in your webinar reminder emails. And that's also going to open automatically in your browser at the completion of the program. We'll send your certificate of attendance once we receive your survey response, but please be sure to respond to the Saul Ewing CLE survey within 5 days of the program to get your credits. And we've also included the survey link in the chat on the side of the presentation as well. Following the webinar, you'll receive a follow-up email that will include links to the webinar recording and with the supplemental presentation materials. Finally, for our legal disclosure, the provision of the information in this program is not legal advice, does not create a lawyer-client relationship, although we'd be happy to form one, and should not be acted on without seeking legal advice from counsel who've been informed of the specific facts of your issues. So with that, I will turn it over to our first presenters, Trip and John. Take it away.
Thanks, Ryan, and welcome everyone to our annual CLE. I'm really excited to have John Redding from Alston Bird joining us today. He's going to start off with an overview of some of the most recent enforcement developments that will impact either directly or indirectly your business. And then I'm going to focus a little bit later on, after John is done, on some of the more interesting redlining cases that have been out there, as well as the recent Fifth Circuit decision on the unconstitutional funding of the CFPB and some of the effects that that's having right now on current litigation. So with that said, John, why don't you take it away?
Wonderful. Thank you, Trip, and thank you to you, to Ryan, and the rest of the Saul Ewing team for the invitation to participate. Certainly appreciate it, and looking forward to it. So what we're going to talk about today, what we're going to start with, as Trip mentioned, is talking about kind of the current regulatory and enforcement environment. And then we'll move on to, in particular, a couple of the more recent enforcement matters that may present some interesting issues and things to be thinking about from your business perspective. But when we look at what's going on, relatively speaking, at a high level, when we had a change in administration, I think all of us were expecting a lot more enforcement, a lot more investigations. There was somehow this perception that under the prior administration with Kathy Kraninger as director, that somehow the Bureau in particular had backed off. It's interesting, just as an aside, to note that actually there were more enforcement actions and consent orders under the Kraninger administration than there were under the Cordray administration. So, you know, this idea that they disappeared for a number of years during the prior administration, I think is not really correct. But it is interesting, since we've seen the change again in administration, and we now, of course, have Director Chopra in place. I think a lot of us, myself included, we were anticipating that you would see a really significant uptick across the board in investigations, meaning issuance of CIDs to more get enforcement more directly out there. We've not seen that. So it hasn't been what we were expecting, but the Bureau remains very active. They do have a number of very large enforcement investigations ongoing. I know that we've got a few of those going. But what we've seen to date, I think, is really a focus, and Director Chopra has made a number of comments on this, that, you know, there have been a number of matters that started not in his administration, and that they are working to clear those out. And I think that we're seeing that because many of the consent orders that we've seen to date, again, not unusual in a newer administration, they are carryovers from a prior administration. But Chopra, I know, wants to get those out based on discussions we've had with both a number of the enforcement lawyers and some of the more senior people in the Bureau. They also obviously are focusing on some very large investigations. You see a lot of pronouncements about them looking at large tech companies, the Googles of the world, et cetera. And supervision remains very active. For those of you who are subject to supervision, I'm sure that doesn't come as any surprise. We've also seen, and again, hearkening back to the prior Cordray era, we've also seen a lot of activity around press releases. We've seen more blog posts. And sometimes, you know, it almost feels like there's a lot being thrown up against the wall to see what sticks. And I don't foresee that changing, to be perfectly honest. You know, we're going to continue seeing press releases. We're going to continue seeing blog posts. We're going to continue seeing guidance being issued as opposed to formal rulemaking, APA, et cetera. And I would say that Director Cordray has been pretty vocal about that. So, you know, it's not what we were expecting, but the Bureau is still very active. And some of the people we work with, I know both at Saul Ewing and we at Alston and Bird, you know, you get that comment, well, but these aren't law. And it's true, they're not law, but they tell you what the Bureau is going to be looking at. They tell you how the Bureau is thinking about the law. And so it's something for you to be paying attention to at all times. So obviously, you know, keep your eye on what they're doing. The Federal Trade Commission, on the other hand, I think is doing exactly what we expected. This is the first time since the founding of the FTC that we have 5 new commissioners. And so you've got kind of this new FTC, very focused on antitrust, which again, not particularly surprising given that the commission is led by Lena Khan, who has made her chops within the antitrust world. So we've certainly seen them focusing on that. We've seen a number of lawsuits filed to stop certain mergers. So I think we're going to continue seeing some of that. But it's important to remember that the FTC also has been very active in areas like advertising, fees, kind of their traditional UDAP with the single A. Not abusive, under Section 5 of the FTC Act. The other thing to note, and you know, I don't think anybody should be particularly surprised, is that the CFPB and the FTC appear to be very tightly coordinated. Not surprising, given, of course, Director Chopra came from the FTC. But when you look at the pronouncements, they tend to come out closely tied on topic, fairly close in time. And so I think we're going to continue to see that type of activity out of them. The FTC, of course, is an enforcement agency. It is not a supervisory agency. So they have investigative powers and enforcement powers. Expect to continue seeing them. I think we see a lot of them, particularly in the auto finance space, because, of course, they have authority over dealers where the CFPB does not. So again, I anticipate we will continue to see CIDs out of the FTC. There are a number out there. They are across industries. I know we've got a few that are in the mortgage industry, a couple that are in the auto industry and other industries. So something to be aware of. DOJ, well, the DOJ is the DOJ. They are continuing to do what they've always done. Obviously, fair lending matters, if found by the CFPB, have to be referred to DOJ where you have pattern in practice. That will continue. And I know Tripp is going to touch on redlining and fair lending related issues a bit later. They're very interested and remain very interested in FCRA, Service Member Civil Relief Act. I think it's important to, again, just remind people that the FCRA, unlike many of the other laws that we all deal with on a daily basis, only requires a single complaint for the DOJ to kick off an investigation. So looking at your FCRA, making sure you've got that buttoned up, is something we all, I think, recommend strongly to you. And last, the last major group we'll talk about, and we've lumped them together, is the state attorneys general and the state regulators, meaning I call them the banking departments, but of course they go by a variety of names: Department of Financial Institutions, California. I don't even know what they're going by now. They seem to change their name every 2 to 3 years. But all very active, continuing to focus on harm. We have certainly seen, particularly AGs, very, very active over the past few years. I know that the volume and frequency of subpoenas and CIDs seems to be increasing. And of course, as we've all seen, the CFPB is encouraging them to enforce, let's say, most recently, the FCRA. There were a number of pronouncements on that. So these are some regulators that and enforcement agencies that I think we just all need to keep an eye on. So I would say CFPB, bit surprising, but still very active. FTC, what we expected. DOJ holding the line, and state attorneys general continuing to accelerate. So something to keep our eyes on. If we can go to the next slide. So now, one thing to note, Ryan mentioned the CLE codes. The first of those codes is shown on this slide. It is 63412. Please make sure to make note of that. And as mentioned, when filling out the survey, you will be asked for these codes. This is the first of the 3 codes that you'll be asked to include. So back in July, the CFPB entered into a consent order with Hyundai Capital America. And this was a years-long investigation. I actually handled this one, so no, it lasted many years. And it was focused heavily on, almost exclusively on the company's credit furnishing practices. And it also included looking at their dispute handling. And what was interesting, and when you read the consent order, you note that the period, it seems to stop in 2020. And yet, as I mentioned, this settlement came out in July of 2022, and we've gotten a number of questions about, gee, why'd they stop there? And the real reason they stopped there is that the company implemented an entirely new back-end system. And that back-end system solved many of the identified issues to the extent any issues remained. And of course, when you read the consent order, I think everybody on this webinar probably knows findings in a bureau consent order are allegations. So I just want to be clear there. But basically, the bureau had alleged a number of incorrect furnishing activities that affected millions of accounts over a number of years. And some of the more difficult issues and areas that they raised and that really affected the ability to, or the time it took to negotiate a resolution, was that they reference, and you'll see this, a number of internal audit reports from 2013 and 2017 that they claimed raised these very issues, but the issues were not resolved. So what are the types of issues we're talking about? A lot of what they talked about was centered around what we call logical inconsistencies. And what that means, simply for those who don't get to spend your lives playing in the fair credit world, and congratulations to you, is that I have 2 data points or more within a Metro 2 file that is going to be submitted to the consumer reporting agencies, and they're inconsistent. And so, for instance, DOFD, which is date of first delinquency, and I've realized that we didn't spell out some of these acronyms, so certainly contact your attorney at Saul Ewing if you need, if you have questions about what any of these are. I'll try to remember to say them. But there were instances where they claimed there was no date of first delinquency, but the account was being reported as delinquent. That is a requirement within the Metro 2, or continuing to report a date of first delinquency when the account is brought current. When an account is brought current, you're supposed to drop the date of first delinquency off. The other issue, or one of the other issues they raised, was this concept of repollution, and the Bureau is very focused on repollution. The idea being that when information is corrected, whether it's in response to a dispute or otherwise, you discover something, you correct it, that information remains corrected. What they alleged here was that consumers had disputed information on their credit report. The company conducted an investigation. As a result of the investigation, they corrected information within that consumer's credit report, but for some reason, the system that was responsible for generating the Metro 2 file did not properly update, and so the previously corrected inaccurate information was repopulated. And so net effect was that the consumer's dispute, while validated, did not stick. They also noted allegations of inadequate ID theft procedures. I will tell you, ID theft is an area also that they focus on specifically. And what they noted here was the failure to properly implement block notifications. That's where the consumer reports, makes a claim of ID theft to the consumer reporting agency. The consumer reporting agency informs the furnisher, and the furnisher is required to block that information unless they subsequently receive notice of a reversal from the CRA. So, and then lastly, and I will say this is the case in every one of these I've ever negotiated or ever seen, and it's been a number, Fair Credit Reporting Act consent orders always allege inadequate policies and procedures. And specifically, what they cite to is Appendix E, Edward, on Regulation V, Victor. And what Appendix E does is it sets forth the types of items and issues that should be covered in policies and procedures. And I would tell you, I've never seen one of these that does not allege inadequate or insufficient policies and procedures. They also didn't like the fact that a number of manual processes were used to address potential issues, as opposed to having systemic fixes. I think that this was probably more of, they were probably okay had these just been short-term interim, but they didn't like the fact that it was manual given the size of the company. If we can go to the next slide. So why does it matter? And I think there are a couple things. This particular consent order covers a broad range of potential issues. And the issues that were raised are issues that are of particular importance to the CFPB, according to the enforcement lawyers we worked with. They noted that these particular issues were the ones that they look for essentially in every investigation. So again, I would commend to you the consent order, take a look at it, and just check to be sure that these issues are not issues within your own shop. The other aspect that I think is particularly noteworthy, and this was a tough one, and that was the monetary relief. I don't think the civil money penalties, as noted here, was what I would call outside the pale or outside what we have frequently seen in actions of this type involving allegations of this nature and the number of accounts affected. If you look at it, the civil money penalty in this matter was $6 million. If you go back and look at other consent orders, it's really not outside the pale. What is very unique and what presented a lot of challenges, this took almost 11 months to negotiate. This is the first time that the CFPB insisted upon and recovered consumer redress for furnishing issues only. Now, there are other matters where they had multiple claims in addition to furnishing and recovered money that was paid to consumers. But in a pure furnishing case, this is the first time this has been done. And the Bureau has stated that this is something they intend to continue pursuing. I will tell you that they have their own method of looking at and assessing, but it is certainly interesting, but nonetheless, something to be aware of. So in light of all this, what should we be doing? And I always think that's the important question to try and answer is, in light of this, what should I do? Obviously, I mentioned policies and procedures. Look at them, compare them to the requirements set forth in Appendix E to Regulation V. Just make sure you're covered off. And having spent many years in-house, frequently I thought we were covered off. And then when you go and dig in, you go, oh, well, maybe I can do X, Y, or Z. Go look. Make sure that you're also doing this on a periodic basis, whether it's annually or however frequently. Second, make sure that people are monitoring. Make sure that the first line, your line of business, and your second line, your compliance, are actually monitoring and addressing issues. Are we testing the Metro 2 file prior to submission to identify logical inconsistencies? And if we find them, are we suppressing the accounts or correcting them prior to submission? The Bureau considers this a critical practice, and so it's something to be addressing. And then as we're going through this, look for root cause. If in our testing we identify an account with an issue, let's make sure that's not a systemic issue. And why is this occurring? Understand that and fix it before you start submitting these affected accounts again. So that's one important piece. Second, make sure that internal audit is engaged and reviewing furnishing. Depending upon the nature of your organization, internal audit may not be part of the financial institution. It may be part of a larger organization. And so make sure that they are looking at credit reporting practices, credit furnishing practices, dispute handling practices, and make sure they know what they're looking for. Then, if they find issues, how are those being prioritized? How long is it taking us to address this? And I think that's very important. As I say, that drove a lot of what was happening here. And then finally, consider periodic review by outside third parties. Whether we are talking about law firm, whether we are talking about consultants, look at your processes, have someone look at them, have someone look at your Metro 2 file, have someone validate that what we believe is in fact the case. System testing is important. And I can't tell you how many times we see this. I know Saul Ewing sees this. I know we see this. It is amazing the number of times that we think we know what the system is doing, but when we go in and dig in, maybe it's doing something else. So making sure that the system's doing what we expected is very important. If we can go to the next slide. A second consent order that I think is important is the Carrington. And here they looked at the handling of mortgage forbearances, in particular under the CARES Act, number of alleged issues. You can see them here. But in particular, they were concerned about the charging of fees. Charging of fees will always be a hot topic with the CFPB. It is, and it will remain. Doing so wrongfully, the Bureau is automatically going to go to consumer harm, remediation, et cetera. And then they claimed a number of misstatements on various topics. They also looked at credit furnishing, and in particular, recall under the CARES Act, you either had to report as current or you had to continue the delinquency reporting that existed at the time of the forbearance. In other words, you couldn't be advancing the reporting. Unfortunately, that's one of the issues they found here. If we can go to the next slide, I want to be sure to leave Tripp some time here. So why does it matter? Again, I think it just shows us that the Bureau is continuing to look at COVID-related practices. We know that's the case. There were civil money penalties. There was the need to remediate the improper late charges. And of course, they then had to go back and look at and adjust both staffing and practices relative to compliance with CARES Act and GSE requirements. So what should we be doing here? Obviously, let's make sure that we did things right during COVID. And this is a function of testing. And to the extent something was wrong, we need to remediate those findings, including modification to any of our actual business processes. And here again, much like in the Hyundai case, looking at our credit furnishing practices, policies, procedures, making sure we're getting those things right. So I think those are really the two important credit reporting related, and you're going to see that there's today a lot of what the Bureau is doing is credit reporting related. We do see some debt collection. We do see a number of others, and I know Tripp is going to touch on a few. So Tripp, why don't I hand over to you?
Great. Thank you, John. That was great. We can move to the next slide. So I just wanted to give everyone sort of this background because of what's going on with the CFPB and whether, aspects of it are constitutional or not constitutional. And so this slide just really gives you a background. Most people are aware of the seal of law case where it ultimately got up to the Supreme Court, and the Supreme Court found that the single director removable for cause only violates the separation of powers. The interesting thing about that is that during the discussion and the oral argument, the Supreme Court said, look, many of the justices said, look, if this is fixed, we're fine. The Bureau is fine. So in fact, that removal process was changed, and ultimately the director ratified all of the prior rules and actions by the CFPB. So, coming out of that case, everyone said, all right, the CFPB is great. All the prior rules and actions are fine, and we're just going to move forward. And of course, that is changed today. There's bigger issues. So next slide. So what we see is we have this community financial services centers versus the CFPB. What CFSC was challenging was the payday lending rules and regulations. And that's it. That's the only thing they were challenging. And they made a ton of arguments at the district court level, arguing why that rule failed. It failed under the Administrative Procedures Act. It failed for a number of reasons. I think there were 6 or 7 reasons that the plaintiff raised at the district court level. And they threw in, and literally you can see that it was a throw in, was that an argument that the rule should be voided because the funding of the CFPB was unconstitutional. And they argued that it violated the appropriations clause of the of the Constitution, which says no money shall be drawn from the Treasury, but in consequence of appropriations made by law. Now, they made that argument, and it was interesting they made that argument because no other circuit court has found, didn't find it then, it hasn't found now, that argument makes any sense. All the other circuits, the 6 other circuits that have heard it, rejected it. Next slide. So the district court rejected all of those arguments, even the unconstitutional argument. And when the case made its way up to the Fifth Circuit also agreed with the district court that all of the arguments regarding the Administrative Procedures Act and so forth were, had no merit. But interestingly, the 3-judge panel that heard this case found that the funding mechanism, and that funding mechanism is effectively that the Treasury Department gives money to the Fed, and the Fed gives money and supports the Bureau. And there's certain a percentage of amount that the Bureau can get. And the Fifth Circuit panel found that that was unconstitutional, as it really wasn't appropriations as the Constitution requires. So we have now this Fifth Circuit decision, and you can go to the next slide, that covers just those three states: Texas, Mississippi, and Louisiana. And it's found that the funding mechanism is unconstitutional. Now, their ruling is covers only the payday lending rule, but you can imagine, they found the payday lending rule was in effect promulgated pursuant to unconstitutional funding, and therefore it was void. And so right off the bat, you see that the Bureau is going to have a real problem in the Fifth Circuit, in those three states, trying to enforce that rule. And of course, while there are six other circuits that have ruled that the funding is not constitutional, that's not stopping those payday lenders who have been either they're being investigated by a CID, or there's actually an enforcement action. They're still challenging those rules in those circuits, in the states that are covered by those six other circuits, and saying that the rule is unconstitutional. But more importantly, what you see is in the new enforcement actions and in existing enforcement actions, the defendants are arguing that they should take the court should take the Fifth Circuit's decision and apply it to whatever the challenge is within those cases. Let's think about what the potential impact of that Fifth Circuit decision is if it were to be applied across in other circuits. We have 12 years of the CFPB rules, enforcement actions, settlements, and guidances that could potentially be voided. And so a lot of people have said, well, why should I care about the Fifth Circuit? And I sometimes agree, I don't really care about Louisiana or Mississippi and God forbid Texas. But the point is that they could be, this decision could be applied by a district court and potentially by another circuit. And all of these rules and enforcement actions will be called into question. And of course, we also look at other prudential regulators, right? The Federal Reserve, the OCC, the FDIC, the Credit Union Association, FHFA, all of those entities are not funded in your typical appropriations process. And so you could see plaintiffs challenging rules, regulations, and enforcement actions by these entities. So those are the two, I think those are the real potential impacts here. And so what you have is the CFPB having to decide, am I going to appeal to an en banc panel or ask for an en banc panel of the Fifth Circuit to hear this appeal, or should I take it right to the Supreme Court? There was a prior case at the Fifth Circuit where several of an en banc review, and that at least 5 of the judges on the en banc panel in a concurrence held that the funding was but had stated that it was their position that the funding was unconstitutional. So rather than the CFPB taking that next step, they decided to seek cert for the Supreme Court. And you can move to the next slide.
And Tripp, one thing that's interesting too is that while this is going on, the Bureau has been very amenable to basically placing cases on hold pending the outcome at the Supreme Court. We're litigating a military lending act down in Fort Worth that was brought by the CFPB against a client. And the moment this came out, we of course filed a motion because we were in the Fifth Circuit down in Texas, but upon filing the motion, the Bureau immediately agreed to a stay, and the court has stayed that case. And that seems to be kind of where they're going right now, pending the Supreme Court.
Yeah, John, that is really interesting. And I just have here some of my notes Three of those cases, one is the CFPB versus Populous, which is a Ace Cash Express, which is a payday lender. That case has been stayed. The Integrity Advance, which is another payday lender versus the CFPB, where there was a $38 million verdict. That verdict has been challenged, but the review of that challenge has been stayed. And then we have most recently the MoneyGram case, which has to do with violations of the remittance rules. That has also been, and that's in the Southern District of New York, a very influential district court. And so that has also been stayed. But what I think is interesting about those stays, and it may also apply, John, to your matter, is it's a question, the question of those cases really focus on the rules, in particular, the CFPB rules and regulations. And so the question is, are those rules and regulations void because of the appropriations? It's not so much focused on the enforcement action itself. And why I say that is just last night, and you'll see in this slide, we'll talk a little bit about the Townstone case. The Townstone also moved for a stay. And this is in the Northern District of Illinois. And the CFPB challenged that motion. And ultimately, the magistrate who was assigned to these motions, because there's also discovery motions in that case, denied the stay. And you can read that decision, it's online. But I think that the reason that the magistrate denied that stay is the focus there is on ECOA, and ECOA is not a CFPB rule or regulation. ECOA, Equal Credit Opportunity Act, has been around forever. It's been litigated forever. Sometimes it's litigated by DOJ. Recently, the CFPB has stepped into the lane and brought actions under or related to ECOA, but that's not its regulation. So I think that might be one of the reasons. So if you're wondering why, how that might play out. If you are facing an investigation or God forbid an enforcement action, and that action is really focused on something other than the CFPB rules and regulations that they've promulgated, it may be a challenge to get it stayed based upon the petition for cert. And by the way, just as it's not really an aside, but so everyone is clear, the Supreme Court has not decided one way or another on whether to take up that case. That petition for cert is still pending. I'm not quite sure why the Supreme Court hasn't acted on that petition. You see every day the news releases saying that the court has decided to take a case or not take a case. This is a really important case, and we haven't seen anything out of the Supreme Court yet on that.
And you're right, Tripp. I suspect our case, which is the first cash case, and it involves a pawn company, where the Bureau brought a case based on alleged violations of the Military Lending Act. So not one of their rules, but I do think it's an important fact for that case that it was located in Fort Worth, Texas. So,
yes,
that made a difference. So sorry to jump in.
Oh, no, appreciate it. So I wanted to focus on two recent ECOA redlining cases for those who are participating, because I think these are really instructive cases. Now, the Townstone case, which I mentioned just a second ago, was the CFPB's very first action against a non-bank mortgage lender. And this is a small mortgage broker in the south side of Chicago. And it really has gotten a lot of play because of the CEO's comments on his own radio program, which is really his only way of marketing. He spends most of his marketing dollars on this radio program, and they talk about all kinds of different things, both national and Chicago related issues. And most of you probably seen that some of the statements he made, which I will say appear to be discriminatory or at least not the greatest things to say about the residents and locations in Chicago. Now, others will argue that those statements were really not derogatory, that they were factual, and that many people in the South Side of Chicago would agree with the way in which he's described those neighborhoods, the activities there. And in fact, the biggest thing that one of the biggest statements he made was where he called the Jewel supermarket the Jungle Jewel. Evidence has shown that that's exactly what people in the neighborhood call it, both minorities and whites in the neighborhood. Of particular note in this case is that 2 years ago, the defendants filed a motion to dismiss, and recently they added to that both the fifth arguments made based on the Fifth Circuit decision, as well as West Virginia versus EPA. And West Virginia versus EPA was a Supreme Court case that found that the EPA had acted outside the scope of its authority. And the defendants in this action are arguing that the actions and claims that the Bureau is making under ECOA are outside of its authority. And I will add that just last night, with respect to that order, there were dueling discovery motions. And I think that it's pretty interesting. The Bureau wanted in its motion to compel an order directing the owner of Townstone to produce all of its communications, text messages, emails for a given period of time. It didn't matter. They just wanted they wanted all of his communications. And the magistrate ruled that was an overreach, but the magistrate did order the production of communications by the owner with its referral sources. And because they're trying to figure out whether or not he's making derogatory statements to his referral sources, and this is just by way of example, hey, send that person to me, but don't send somebody else to me. So they will have to produce that unless they appeal, and that magistrate decision is overturned. The defendants in this action also had a motion to compel, and in that they wanted all of the internal communications by investigators and lawyers at the CFPB regarding their attitude towards the statements made or allegedly made, and also the elements of an ECOA violation. We've seen this before, where defendants take a very aggressive approach and are trying to get the same type of discovery that they might get in a civil action from the Bureau. But again, not surprisingly, the magistrate denied that motion in part, but did issue an order that required the CFPB to produce communications, which he found not to implicate the attorney-client privilege, about the actual statements alleged to have been made, as well as whether or not there's any actual evidence of discouragement as a result of those statements. And I can tell you, because I have colleagues who are defending Townstone, and they are sure that the Bureau has not found one bit of evidence that there was actual discouragement, notwithstanding the HMDA data, which some people in this case have alleged that the Bureau has manipulated, but actual evidence where on the ground individuals are saying, I didn't make an application, I didn't even consider making an application to Townstone because of these statements. And so that'll be a really interesting, if the Bureau can't produce one stitch of evidence that anyone was discouraged, actual discouragement, that'll go a long way in this case. And then I wanted to focus on the Trident mortgage, which is a DOJ and CFPB enforcement. Well, it never got to an enforcement action. It was just an investigation, and it was very similar to Townstone. They used internal emails and communications to begin their investigation of Trident mortgage. There were, again, some external emails that came into Trident and then was circulated. They were disparaging. And from that, the Bureau then started to investigate, just like in Townstone, where did Trident have its offices? Who were its employees? Did he have minority employees? Did they do minority marketing? Did their marketing material reflect the minority communities or not? And that's very similar. The arguments about, you're discouraging, by the Bureau, you're discouraging minorities because you don't have LOs that are minorities. You're not marketing in a way that would encourage minorities to make inquiries for mortgage loans. It's a quite different concept than affirmative discouragement, and I think that's it's a little bit concerning for me and for my clients that it's not about discouragement anymore, but rather encouragement. And so those are two cases, and it's a $20 million settlement. Home Services is the parent company of Trident Mortgage. Home Services is paying that, and it's primarily in community outreach as opposed to payments directly to consumers. And Home Services is paying that because Trident, during this investigation, was shut down. But that was Home Services' decision. They have their own mortgage company. They don't need Trident Mortgage anymore. And I think it also had to do with Home Services being such a large, multifaceted real estate settlement services company. I think the Bureau threatened to start doing investigations of its real estate agencies and brokerages. And I don't think that anybody at Home Services wanted that to happen. So, in keeping with these two cases, we see that this year, the CFPB announced that it was unveiling a broad expansion of its supervisory procedures to include discriminatory conduct. And what the Bureau thinks is discriminatory conduct is still sort of in the ether. It's, again, very similar to what it's done in the past. Is if we see it and we think it's discriminatory, then it's discriminatory. And they've used that type of approach to say if it's discriminatory conduct, we're going to apply the UDAP elements, even if it may not be that conduct would be subject to an ECOA violation. So they've really expanded that. And I want to add, in the short amount of time that I have, is that we're talking about origination here, but let's be clear. This type of expanded supervisory procedures that you see here on our slide also is going to be applied to servicing. So it's really a question of, is there discriminatory servicing? Is there fair servicing? And I think you're going to find in the years to come, at least over the next 2 years, that when there is investigations and supervision of servicing by the Bureau, or maybe even complaints that reach their way up to the DOJ, that's the model they're going to apply. So it's something to keep in mind going forward. Next slide. Oh, there I am. So that's really where we are. And look, I ended just on time. So the takeaway here, I think, is that the question is, what's the Bureau doing? Well, we saw from John's comments that certainly fair credit reporting is an important, but I think that equally important is this notion of discriminatory conduct, this notion which is sort of expanded into this discouragement. And then one step further is it's not so much about discouragement anymore, but are you, are you doing enough to encourage? Are you, both in the origination and in servicing, are you doing things that would have a minority member fully understanding what you're doing and not feeling sort of left behind the curtain as to what your conduct is, why we're being charged this, why these things are happening, why, am I getting a full response to a QWR? This is a key focus for the Bureau And I know I've been on a couple panels with the head of the fair lending at DOJ, and they are clearly working hand in glove with the CFPB on these issues. John, I don't know if you had any thoughts on that.
No, I think you've summarized it well. ECOA and even the non-ECOA UDAP type of discriminatory conduct that the Bureau has been interested in, they'll continue to look at. Patrice Ficklin, who of course previously headed up the CFPB's Fair Lending Office under the prior administration while she'd been moved directly under the director, has kind of moved back out. There continues to be interest there. And so keep your eyes open, because as you've mentioned, redlining is a hot button item for them. And the Bureau is also wanting to look at fair servicing and trying to understand when are deferrals being given, when are other types of benefits being given, when are settlements being made, and who's getting the benefit of those? Is it because of discriminatory conduct? So I think all of these things, as you're saying, are areas to keep our eyes open and keep our eyes on as we're going forward, and making sure that our policies and our procedures don't run afoul of them.
Absolutely. And in closing, I would just recommend that everyone on this presentation today, keep an eye on the Townstone matter. It really is probably next to the Fifth Circuit and decision and the Supreme Court's approach to that. The most important case that's out there for a variety of reasons, in particular that the Bureau, if they are successful in this case and it is not dismissed, it really, to me, opens the door to them and sort of, what other statutes they can rely upon and what other approaches they can take to, root out what they see as discrimination. And not just your typical standard historic definition of discrimination. So at that, thanks for listening, and I will turn it back over to the next panelist.
Thanks, Tripp. Thanks, John. That was terrific. So we're going to jump right into our next panel. Give everybody a minute just to jump on, but I'm really excited about this next panel. Excuse me, which is going to be a roundtable discussion on some really interesting developments in arbitration. We're going to discuss the recent increase in consumer arbitrations designed to repair consumer credit reports, and also the emerging risk of mass arbitrations. But before we dive in, I just want to give everybody the opportunity just to introduce themselves, starting in no particular order. Zach, you want to lead us off?
Yeah. Hey, everybody. Thanks for coming today. My name is Zach Miller. I'm an attorney with the law firm of Burr & Foreman in Nashville, Tennessee, and honored to be presenting today.
Leah, since you're next on the screen.
I'm Leah Everly. I'm in-house counsel at Bread Financial, which is client data. And we primarily focus on offering a variety of consumer financing products, so primarily private label, co-brand credit cards, pay in 4 products, and monthly installment loans.
Great, thanks. Rich?
Hi, everyone. Rich Lee, CEO and co-founder of New Era ADR. I'll share a little bit more about New Era as we get into the discussion. Real quick background on myself. Attorney for 17 years, started my career in IP, was general counsel of 2 different tech companies before co-founding and launching New Era.
Great, thanks. Caitlin?
Hi, everyone. I'm Caitlin Burke. I am the Vice President of Litigation for Rent-A-Center, Inc. We're based in Plano, Texas, but I have lines of business based in Utah and nationwide, Mexico, and expansion into Canada. We do have rent-to-own products and are exploring a credit product, so lots of new developments for my company.
That's great. All right, thanks everybody. Can we move to the next slide? So before I hand this over to Zach, I just want to briefly set the stage for our first topic, right? In the past year or so, we've really begun to see a material increase in arbitrations filed by consumers and credit repair organizations designed to address negative information contained in a consumer's credit report. Often the credit repair organizations are just looking to delete or modify these trade lines, remove a negative notation such as a 30 or 60-day late designation, from what I've seen to date, many, if not all of these challenges are manufactured. They're designed to clean a consumer's credit report. Thus, furnishers are faced with the difficult decision of whether or not to pay the arbitration fees and the costs associated with defending these claims, or simply modify or delete an otherwise accurate report. I'll discuss my thoughts on why this may not be a difficult decision and the potential regulatory risk associated with modifying or deleting an otherwise accurate report. But first, I'm going to give it back to Zach, who's going to discuss another really interesting aspect of these cases, which is, the credit repair organization's direct involvement in these cases and the ethical issues that that's going to create. So, Zach, take it away.
Yeah, thanks, Ryan. My screen froze, but you can see me, right?
Yep, we got you.
Okay. All right, great. This has been something that's been on the uptick probably for the last few years, I think since the pandemic, which is non-attorneys who are starting these credit repair businesses and starting to bring claims on behalf of consumers. And over the last 6 months, it's been a dramatic increase. And I'd say over the last month or two, I can't even believe how many of these I am seeing. And in fact, just as we were watching the last presentation, got an email with yet another credit repair company, this time in North Carolina, where somebody is threatening an arbitration on behalf of a consumer. And so what we've tried to figure out at Burr is, how are we going to battle these? And I've been talking with Ryan about it, been talking with colleagues all over the country, because there are a lot of problems presented by non-attorneys representing consumers. The first is that a non-attorney is not bound by, the standard ethical guidelines and rules that regulate the practice of law. So if I am negotiating with the non-attorney to try to resolve a case, because I've made the decision that it's easier to do that than fight them for unauthorized practice of law, do they have an ethical obligation to go back and tell their client about the settlement offers that have been made? Do they have a obligation to conduct themselves with decency, with fairness, not to lie, not to invent evidence? I think that the answer is no, that they don't have that obligation. And so that presents a lot of tricky problems. And, what we've decided to do, and I'm not quite sure that this is, the right tact, but is not to negotiate with these folks to the extent that it's possible. So to contest their inclusion in arbitrations as strongly, firmly, quickly, decisively as possible, and are considering, in at least one situation and maybe more, enlisting our clients to file bar complaints against individuals that are, engaging in the practice of law. And what you'll see a lot of times is that these demands will come with a power of attorney that's executed that purports to give the non-attorney representative the same rights and obligations and responsibilities and that the consumer has. But really, if you look at any law regarding powers of attorney, how they're used, it's clear in every state that it does not, supplement law, or it does not do away with law school, that you cannot represent somebody else just by having a power of an attorney. It doesn't give you the right to make legal arguments in a proceeding. And so those power attorneys are as useless as worth as much as the piece of paper that they're written on. And so what we're going through now, and I don't have perfect advice on this because, we're currently battling at least a dozen of these individuals all over the country, is, fighting back as strongly as possible, and we'll see where that goes. What I can tell you is, just from quick experience, a lot of times, so look at your arbitration provision and see what it says about consumers paying fees. Most of the time, JAMS and the AAA, the consumer must pay $200 to initiate a claim. However, a lot of us in our arbitration provision state, we'll pay this amount for you if you can't afford it. Well, when we actually go through that process and require them to send in evidence or send in a letter saying they can't afford to pay the arbitration fee, a lot of these, non-attorney representatives won't even go through that hassle. They charge like an initial $250 fee to clean up somebody's credit, and filing these arbitrations is included. Well, if they're paying $200 to initiate the arbitration, that eats up almost all their fee. So a lot of the cases kind of fall off just from the fact that they don't even ever pay to initiate the arbitrations. And then once they do, a lot of times, because again, they're not subject to the same ethical rules and guidelines, they'll ghost their clients at hearings. They just won't show up. So I think that's a good summary, Ryan, of where we're at. And then I guess I'll turn it back to you for additional questions.
Yeah, do you want to go through the distinction at all? We have 2 additional slides on the difference between the AAA rules and the JAMS rules, and whether or not, do you really see a distinction? Can we flip to the next slide? Between the representation rules that are in the AAA and JAMS?
Yeah, so this is something that we've struggled with. The American Arbitration Association and JAMS, neither of them are really set up well to address disputes before an arbitrator is appointed. They don't really have a way to, if you have some sort of requirement that certain steps must be taken before a claim is filed, they don't have a way to vet those. They don't have people that are employed to go through and fact find and make a decision before an arbitrator is appointed. And so what they do in 99% of the times, if there's some sort of dispute regarding the location of the hearing, who the representative is, pre-suit procedures and checklists, they'll say, well, bring this up when the arbitrator is appointed. And that's what we've seen. So if you look at the actual rules in the AAA regarding representation, and rule R25 is what it is, and I can't see what it says right now because literally my screen's frozen. But it says basically a party may participate in the arbitration with any representative unless prohibited by applicable law. So there's that caveat in there. The AAA, how they interpret that as an administrative agency is they'll allow anybody to represent anybody. They're not gonna find that someone can't represent somebody unless the arbitrator does. So practically speaking, how this works is if you're a respondent, you pay your $300 for your filing fee, and then you pay $1,400 for the arbitrator to be appointed, and then you pay $2,500 for the arbitrator's compensation. And then at that point, you're having the scheduling hearing, and then is the first time that we can bring up, hey, this person shouldn't even be allowed to represent the consumer because it's prohibited by applicable law. So for example, the state of Ohio says that a non-attorney cannot represent somebody in an arbitration proceeding, even if they have a power of attorney. This is illegal. This person is violating the law. That, of course, also brings up the other issue, which is that I think as lawyers, when we know that someone is engaged in the unauthorized practice of law, we may have an obligation to actually go and report that to the appropriate authorities. And so, when you bring that up, when you try to disqualify someone, it can get a little bit sticky. And where I get particularly concerned is if we're settling with some of these folks, but we're, really fighting back and claiming UPL against others, that can present issues because, threatening someone with criminal proceeding, or maybe settling a case and not threatening somebody else, the allegation or, even just looking like there may be blackmail involved, we're not going to turn you into the state bar if you settle for this favorable amount, is something that concerns me, which is why we've taken a hard tack to fight these people regarding their representation in all these matters. So the AAA gives us one tool. They say, okay, unless prohibited by law, and that's helpful, but we haven't yet had an arbitrator rule on that just because of the myriad different things that happen to these non-attorney representatives before we even get to a scheduling conference. And then flip to the next slide. I believe it's the JAMS rule. JAMS doesn't even have that caveat in there. So they basically say you can have anybody representing you. It's your choice. That being said, I don't think that the JAMS rules itself specifically make something legal that is illegal, and so I would make the same argument before a JAMS arbitrator that allowing the non-attorney representative to represent a consumer in an arbitration proceeding violates state law, and we're all participating in that violation if we don't bring it to the attention of the arbitrator and the arbitrator allows it to happen.
Yeah. Leah, I'm interested in kind of what your experience has been with this, and have you guys seen this, and how are you guys, how are you dealing with it from an in-house perspective?
Yeah, so we have seen it come up, and I would say really it exploded almost overnight. So the last, I don't know, 6 to 9 months started to come up and hasn't gone away. Once the floodgates were open, they were open. A lot of the things that Zach had mentioned are things that we've explored. In addition, we've also looked at the terms of our credit card agreement as far as contemplating non-attorney representation. And that's another thing that we've used to push back on some of these credit repair organizations, is that the terms of our credit agreement don't contemplate non-attorney representation. And at least in a few situations, that has been helpful to us in combating some of these.
Caitlin, how about you? Have you guys seen something similar?
Yeah, same thing as Leah. We have tried, so we inserted pre-arbitration dispute requirements, and we have tried to enforce those as a method of getting these people to go away. But like Zach pointed out, we have a template letter that we send AAA that say this case shouldn't even be seen by AAA and ask for dismissal. But whether or not they appoint an arbitrator to actually decide that, or they just sit on their hands and effectively like don't do the case, we still have to pay the arbitration fees. So I haven't found a very successful method yet, but these non-attorney reps do fight back very, very hard when I send that letter that says this is not even properly before AAA and you should dismiss it.
Yeah, and look, I mean, I think I come out in the same place that we all do, that I think we have to undermine the business model from the defense side. And I think the other piece of it that we haven't touched on is, I don't think that companies can delete or modify otherwise accurate trade lines. So that sometimes is a piece of the relief that the credit repair organizations are founded on, right? They get hired by consumers to come in and assist them in modifying it. But if you as the company believe that this trade line is being accurately reported, under the FCRA, you have an obligation as a furnisher to report accurately. And the CFPB has previously come out with on numerous occasions and warned furnishers not to simply delete credit reports upon receipt of a dispute. And I believe that simply deleting or modifying an otherwise accurate report, even to avoid an arbitration, could potentially run afoul of this direction and create additional regulatory risk. So that's something else to think about. And again, if I'm with Zach, that I think the idea is you really need to push back on the business model. Otherwise, they're going to keep taking money from consumers. If you make it easy, or we as the defense bar make it easy on them, they're just going to continue to sign up more and more consumers for this. If they have to spend hours on the phone or potential briefing, it eats up the fee that Zach was talking about. So the other thing I just want to note is that the ethical considerations are really state specific, right? And so in New Jersey, a non-lawyer can't serve in an arbitration function, but there are certain exceptions. One of those exceptions is if the representative is needed to consult with parents of special needs children or represent them in administrative hearings. And that's because there is a public interest in the assistance and representation of those parties. I'm sure that the credit repair organizations would try in New Jersey to make that argument, that they serve in a similar function for the public interest. I'm not sure that I would agree that they do that, particularly when they're taking fees and ghosting people, as Zach pointed out. But it is something to keep in mind. The other aspect that we've looked at is, how do you settle, right? Because if you decide that you do want to resolve, how do you undertake that potential resolution while protecting yourself and protecting the company? Have the settlement signed only by the consumer, obviously. Include a statement that the claimant hasn't relied on the advice of the non-lawyer and has had an opportunity to consult with independent counsel, and then pay the consumer directly. Those are just 3 things that we think can help try to mitigate, the risks of resolving this. Jack, you have
Right.
any? Yeah, go ahead.
Yeah, I just wanted to say a couple of things because there's some interesting comments. I mean, regarding paying the consumer directly, I mean, my belief is that depending on your state rules, you're not prohibited from contacting these consumers directly. So if there is a case that you want to get resolved, the consumer has brought up something legitimate, but you don't want to negotiate with this non-attorney representative, I don't believe there's any ethical issue with reaching out to the consumer directly. And we've done that routinely. We've just cut the non-attorney representative completely out of the picture. We have not negotiated with them, and we've reached out to the consumer with the contact information that we have on file. Another thing Caitlin said that was interesting is that these guys or women fight back really hard when you push them on UPL or the fact that they can't represent somebody. I sent a letter on Friday to somebody in Pennsylvania saying, look, we're not going to negotiate with you. We believe you're engaged in the unauthorized practice of law. They responded immediately with a claim that I was slandering them and it was defamation. And then they wanted $24,000 from me. So it does require some discussion with maybe like your general counsel, or if you're in-house, you might want to be in, continuous communication with your outside counsel regarding the fact that these people are going to file bar complaints. They're probably going to name our law firms as defendants. They're going to name us as defendants. And it's just some additional risk as outside counsel that you have to take advantage of, or that you have to take into consideration. And then finally, I wanted to read this website. So my belief has been and continues to be that this is a YouTube and social media caused problem. There are people on TikTok, especially, that are claiming, any type of negative information that you have on your credit report is actionable. One guy actually posted on his Twitter, some guy that I do battle with routinely, that credit denials are as good as money because they're illegal. And he goes, I don't even care if it's not discriminatory, you sue. So this is social media and YouTube driven. And here's this guy. So his name is Sammy Dodd, North Carolina guy, just got it. And his website, and he has an About Me section. One of the things Sammy did was research the FCRA and FDCPA, and he started looking for attorneys to learn about the law and how to draft an effective dispute. One of the attorneys Sammy found was John Watts, who teaches consumer law on YouTube. I know John Watts, he's a lawyer in Birmingham, and he does give tips on YouTube. And he says, while binge watching John's channel, gathering ideas for generating factual disputes, Sammy got on a live broadcast with John. This was the defining moment that began his journey to credit wellness. So this is what we're battling. And this is why they're coming out of the woodwork, because it's social media driven and it's a wildfire.
I think we wasted a lot of money on our law degrees. Who knew that you could just go binge watch YouTube and be in the same position that we all are?
Yeah, who cares about the bar?
Yeah. Well, it's interesting, kind of using that to pivot about social media and emerging technologies. I want to turn to kind of our next topic and talk about another really interesting issue that is really coming up quickly on us, which is the emerging risks associated with mass arbitrations. Just to level set, mass arbitrations are what have been described by consumer advocates and plaintiffs' counsel as the counteroffensive to mandatory arbitration provisions and class action waivers. Where consumers are unable to file class actions due to these waivers and arbitration provisions, plaintiffs' attorneys are now simply signing up hundreds, if not thousands, of individual claimants and threatening or filing individual arbitration demands on behalf of each of their clients. So what's the goal? Their goal is to create leverage by attempting to saddle the defendants with potentially tens of millions of dollars in arbitration fees alone, just the filing fees. Plaintiffs' attorneys have effectively turned these arbitration provisions on their head and are using them to extract million-dollar settlements from defendants to avoid the filing costs associated with the arbitrations alone. Defense counsel have described this tactic, I believe correctly, when they say it is the weaponization or weaponizing of these arbitration fee schedules to extract millions of dollars in settlement funds for baseless claims. The reality is that technology and social media has changed the game. what would have once been nearly impossible to locate and sign up thousands or tens of thousands of consumers into one mass arbitration action has been made much easier and manageable through social media and other technology. Much has been and will continue to be written on the topic, but including, what the origins are of mass arbitrations and what led us here. And we've highlighted just a few of the recent publications, which are really interesting reads on the topics. But I think today, I really want to hear from the in-house folks who we have on, and also from Rich, who have actually gone through some of these issues and taken certain actions to mitigate these risks. So against this backdrop, Caitlin, I think I'd like to hear from you first on, what your experience has been, and then what steps your company has taken to kind of address the risk.
Yeah, so my experience before I started in-house was in arbitration agreements. So I became an arbitration expert. I did appellate work. This was like my bread and butter. And this kind of dovetails perfectly with the question that Lauren has asked: is there still value in mandatory arbitration agreements? One thing I will say as a cautionary tale is, if any attorney says, here's a template on your arbitration agreement, it's just a form, just put it in place, you should really be very skeptical. You should go back to your outside counsel, because you need to have a customized arbitration agreement, and especially now with this mass arbitration issue. So I look at my arbitration agreement a couple times a year. I'm doing it right now again, even though I've already done a 2021 version, I already did a 2022 version. I'm looking at it again in light of the state of affairs. And one thing you look at is, how good is your class action waiver? How good are your protections against mass arbitration? Are there any other venues in which you want to call out and use? So the mass arbitration procedures, this threat of mass arbitration has been around for probably 10 years at this point. So we were always talking about it and warning clients, like, you need to incorporate provisions. I got very aggressive this year, and I asked our outside counsel to collaborate and give me several options. What's the most aggressive option? What's kind of the middle of the road, but still suits my business? And then what's kind of the least risky? I did a combo where I have like 4 different provisions in my arbitration agreement now, specifically designed to combat mass arbitration. For example, one of them is I require the actual plaintiff, not these non-attorney representatives, but the actual plaintiff, to sign a personal signature that describes their claim and submit that as a pre-arbitration notice. That triggers us then to move into either an informal settlement conference or a cooling off period. So those 2 requirements stacked makes it more difficult for them just to go to the AAA and say, okay, here, AAA, let's go. Here's, hundreds upon hundreds of arbitration demands. They actually have to consult with us. And there's this long cooling off period of like 60 days where we say, let's discuss your claim. Let's see if we can resolve it. And it puts just a couple barriers, which we still feel like are enforceable and within the law, but makes them think twice about how easy of a target is my company versus another one that just has the form template with no mass arbitration protections.
I think that's super interesting. Have you found that the cooling off period has been effective? Have you been able to resolve disputes and head some of this stuff off?
Yeah, I think it's been very effective. So in my business, we have a lot of repeat plaintiffs' counsels. So I was able to, 1, eliminate a lot of them because we were becoming so difficult. And 2, the ones that are still repeat suing us, we have very rarely moved into arbitration compared to, say, like 2 years ago, because they'll negotiate directly with my in-house team or outside counsel, depending kind of the risk and how we triage the case. So getting that rapport with these repeat players, especially when, let's be honest, the same attorney firms file over and over these fair credit reporting, these collections actions, you harassed us. So if you get to know them and have the relationship, they probably want to skip AAA too. They don't mind dealing with you.
Yep, I think that's right. Can we take down the slide? I think it's easier if we just see everybody. I don't think we got a chance to. That's good. So Leah, can you tell us what your experience has been and what you guys have done?
Yeah, so a little bit similar to what Caitlin was saying is we looked at our arbitration provision and looked at different options of ways that we might revise it. And I guess I'll back up 1 second. We were actually the recipient of one of these fun love letters from a plaintiff's firm with a long list of claimants. So based on that, we looked at things that we could do to kind of get ahead of this in the future. And again, looking at more aggressive to less aggressive changes. One thing that we did do, again, very similar to what Caitlin mentioned, was beefed up our notice and cure provision. So requiring signature from the claimant, individualized letters, that they couldn't send one mass letter with a list of names from each individual. And I think that has been helpful. And we did have a notice and cure provision in there previously. What we've seen, though, and others I'm sure have seen it, is a shift over the years of concern that your arbitration provision would be found unenforceable due to unconscionability. And so now that concern, I think, has lessened some. And so therefore, being able to make your arbitration provisions work for you and your needs has been helpful. So we did look at our notice and cure provision, strengthening, requiring a wet signature. We also looked at, and this I'm sure we'll talk about with Rich here in a little bit, our arbitration provider selection clause. Previously, we had AAA and JAMS. We ended up removing JAMS just due to the expense associated with JAMS. We did leave AAA, but wanted to leave it open to other types of arbitration providers, and so included a clause about having it up to the mutual agreement of the parties. And part of that discussion, we looked at some of the new arbitration providers out there, and that those could be helpful, and leaving that open for discussion. So those were a few of the changes that we looked at making in our arbitration provision. We looked at other things, also fee shifting. Previously, again, when there was really concern about how consumer friendly our provision was, we had certain fees that we had covered, and now it's more shared fees, pushing back on the fee waivers. Consumers would need to pay their fees and not just automatically be paid by us. And I think Zach had maybe mentioned that a little bit earlier about the different amounts of fees that consumers could be required to pay, depending on the provider. So just a few of the things that we looked at.
Yeah, that's great. I mean, Leah, you since you mentioned that you guys had actually had an experience, can you just, for the benefit of the group, talk through how you handled that?
Yeah, so one thing that was helpful was we have people in our business and others that look online to see where our name is being mentioned, kind of try to get ahead of things. So we did actually see some of the social media advertisements before we received the love letter, so we knew something was kind of coming, and there was very, very little information, and that played into when we did get this letter. They collected very little information, so there was very little information for them to go on. And you can go out there today and there's tons. You can Google and find some more advertisements. One of the bigger plaintiffs firms in this area even has a web page on their website, and you can see all the people that they're gathering names for and all the different companies today. So I would say getting ahead of it was very helpful, just kind of knowing something was coming and knowing what to monitor. We were able to take screenshots of their exact advertisements, see exactly what information they had, so we knew when we were pushing back and asking for information, what information we thought that they had, and that all proved to be correct since we saw their advertisements. One thing that was interesting was of this list of names that they sent us, some of them were not even our customers at all. Many, not even an immaterial amount. A good amount of them were not cardholders or customers, people that we had no relationship with at all. They filled out a form on social media hoping to get paid. So all of those things ended up being helpful, that having gotten ahead of it, I guess, or being aware of the full process from the beginning proved to be helpful in the end.
So you're saying they weren't really vetting their folks. I'm shocked. I think one of the questions that comes up, and I'd be interested if you guys looked into this, is, were there any affirmative steps that you could take in attacking that advertisement? I mean, we usually come at it, we've looked at this issue before, and I think the answer is generally no. But did you actually look into that? And Zach, if you have comments on that too, I'd be interested in what your thoughts are.
Yeah, they were very, there really wasn't a lot to them. It was, have you been harmed by big bad company? So give us your name, first, last name, and email. So there really wasn't a lot to go off of there.
Yeah, Zach?
Yeah, I've signed up as a client to some of these mass arb folks just to see what their process is like. And yeah, like what I've seen is it's 8 pieces of information. 2 of those are your first name and your last name, and then a bunch of yes or no questions. So this mass arbitration model works a lot better for marketing claims or data privacy claims where everybody's treated the same. So if you're alleging someone's violating like an Illinois statute, that, has certain requirements in there regarding privacy, what data you can or cannot collect, you don't really need a lot of information from the consumers because everybody was treated the same. In the consumer finance aspect or arena, all accounts are different. And most claims, whether they be disclosures or how you were treated during servicing or some type of fee that was charged, is going to vary from consumer to consumer. So we have a tool in the consumer finance space to fight back, which is to, pick apart their claims at the very beginning. We haven't had much luck though, taking down advertisements, have looked at state bar rules on that. And really, unless there's a really clear misrepresentation in there, it's just kind of part of the game. You have to let those things fly and then attack them based upon the information that they obtain.
Yeah, that's a conclusion we've reached too. Caitlin?
Yeah, I was going to say, Zach, we have attacked it in our settlement agreement. To the extent you can reach a settlement, we do include the strongest clause we can that, like any sort of advertising use of this person's testimonial needs to be taken down. And to the extent you get a lot of those, then they're like, well, okay, fine, we'll just take down, the whole site.
Yeah. All right, Rich, I think we'll turn it over to you. How are we going to solve this? You're going to fix it.
I think it'll be helpful with, just for everybody here, just to provide some context on, who we are, a little background and where we're coming from. So as I mentioned, I've been an attorney for 17 years, but my co-founders have been as well, right? So we started this company, 3 of us are ex-GCs, attorneys for 17, 21, and 15 years. And then, our 4th co-founder, head of compliance, legal operations for, I think, going on 20. And so we come at this from personal experience, but also just frustration overall about the litigation system period, right? Which is the simple fact that, our belief is that for 99% of the legal disputes in this country, so, call it your non-highly complex trade secret litigations, your patent infringement defense cases, we think most of these cases are ones where companies, individuals, they want to get these things resolved really quickly. But of course, the current set of procedures in courts, traditional arbitration forums just don't really allow for that. And so the premise and the kind of foundation for us, which I think underpins everything that we'll talk about with mass arbitrations, is the fact that we took a very radically simplified approach to arbitration, right? So we're a tech company, we built the platform, but then we said, you can build all the tech in the world. If the underlying rules aren't changed, litigation is not actually going to be faster or cheaper. And so we spent the better part of, about a year and a half, building those set of procedures, running it by, our legal network, as well as people outside our networks before we launched. And so on our platform, from a case-by-case standpoint, you'll get binding legally enforceable decisions in 60 or 100 days. And that's because we've drastically reduced, 2-party discovery. We've drastically reduced motion practice. We've put economic incentives in place to make sure that the parties, the neutrals themselves, are, incentivized for efficiency. And this is built, right, for meaningful legal disputes, not, your $10,000 eBay claims, because, we were all kind of GCs of tech companies. And this was a place where we wanted to bring our own disputes. And we have countless stories ourselves, right, of arbitration or litigation where we were forced to settle. So after we built kind of that, and of course, recruited a really experienced set of neutrals, arbitrators and mediators, which we can certainly talk about separately, then we turned our attention to, some of these just inefficiencies in the market, right? And so keep in mind, we are a neutral platform. And so when we looked at the mass arbitration angle, we looked at it through a neutral lens, which is, and what we came away with was, the filing fees at these traditional forums, they actually act as a gate, right, to these cases actually being heard, actually being considered, which, if we want to talk about our judicial system, that's what it should be about, right? The cases, the plaintiffs, we have to assume that they were actually wrong, that they all have meritorious cases, but are they actually considered? Are they heard? And right now in these mass arbitration contexts, a lot of times what you're of course seeing and what we're all discussing is the fact that, these fees kind of force these settlements. And then when money changes hands, the consumers don't actually get heard. And so we thought to ourselves, how do we build and what can, other forums do, right? To build a forum where, hey, let's reduce that upfront cost. Let's make it possible and affordable and cost effective for these cases to proceed. And so we designed, our platform and our fee structure and our set of mass arbitration procedures around that, right? So kind of in two parts. The first part is, getting the cases to, to actually be heard. We drastically reduced filing fees, right? And then we work with companies and we ask companies to basically pay a subscription fee to help subsidize that, if and when, mass arbitrations were to actually proceed. And companies also then can adopt our procedures so that they don't have to get too creative, right, with their arbitration clauses. Because, as I know several of you have already kind of touched on this, these are being challenged in court. Ryan, I saw on one of the slides, one of the cases in the Central District in California, that challenged, a large telco's, arbitration clause, right? And so this kind of gives the companies the ability to simply point at something that has been, vetted now by countless, large companies, large firms, you name it. And so when the fees are significantly lower, and we're talking about, on our platform, it's $300 per case, flat fee, all in. That's not a filing fee. That includes arbitrator fees. There's no, bill later on for arbitrators. There's no cap on the number of cases unless, companies negotiate it with us. And so what that does is it now makes it highly affordable for these cases to proceed. But of course, as you're all probably picking up, what this takes away is, and what this potentially disincentivizes is the, frivolous cases, right? Because if you have a frivolous case, it will go be heard. It will go be considered on the merits. And then for us, step two was then, okay, well, if the cases actually go and proceed and are now on the path forward to, being considered, what does that look like? Because now, and I saw another case cited on that slide. It was a 50,000 case, mass arbitration right here in Illinois. Like, how do you churn through 50,000 cases? We've seen, instances of, kind of batch arbitration or like group arbitration procedures being challenged and being struck down because it's going to take way too long for these cases to proceed and, actually be heard. And so, we adopt kind of elements of a bit of an MDL model, and that, we adopt the concept of bellwethers, and have the bellwether cases go through full trial on our expedited platform using our expedited procedures. So even those trials themselves aren't going to take forever. But then we kind of take it a step further, right? So in MDLs, the kind of bellwether decisions and a lot of the precedent that comes out, it's used to guide a lot of the global settlement discussions. We take it further. We do have a settlement phase after the bellwethers, basically requiring that the parties enter settlement conference and discuss, hopefully resolving, the balance of all the cases. But if they don't, we do allow our arbitrators to kind of basically pull that precedent through, right, and apply it to all the other cases. And then the parties themselves then have the opportunity to make, individual arguments, that certain cases are different. But as Zach was mentioning, in a lot of these cases, right, the facts, the common issues in law and fact are, nearly identical. But the parties do have that opportunity to make that argument.
That's great, Rich. I really appreciate that. I think it's really interesting. I mean, one of the things that jumps out to me as you're explaining it, so the $300 fee being kind of a flat fee, but how does then the company operate? You mentioned the kind of subscription. Is it almost like an insurance model then, that the idea is that you spread the cost across many different companies for the risk of these mass arbitrations through the subscription fees?
Yeah, the subscription helps subsidize a portion of those costs, the administrative costs, right? We still shoulder, a lot of the risk and the burden ourselves. But that's to kind of basically help defray it and get access to, the $300 per case fee. Because otherwise, our traditional just kind of flat fee model is we charge a flat fee per case. Again, we don't charge filing fees, administrative fees, or anything, even in our individual cases. So typical like commercial arbitrations are $10,000, right? But then, and that's a flat fee as well, typically split between parties. Also no arbitrator, invoice at the end. But of course, that fee on its own is also cost prohibitive when it comes to the mass arbitration context. And so it was our kind of solution to, adjusting for these kind of mass actions essentially.
Rich, has anybody that incorporated the new era rules yet been subject to an opposition to a motion to compel arbitration, or any argument that the bellwether system is unconscionable yet, where we've had a judicial decision on that?
Not yet, but there is a case pending. In the Central District, we're not a party to it. I'm happy to share the case, offline. But that it is, around that, but it's actually not about our procedures themselves, right? And as you can gather from the docket, once you go through it. And I'll share the case name here. It's Heckman, Heckman, v. Live Nation.
Yeah, I think one of the other questions I do want to get to, because we're pushing up against it, is whether or not, and I'm interested for kind of Caitlin and Leah's perspective, is does mandatory arbitration even still make sense? From your perspective, given the challenges with non-lawyers filing arbitrations, do you still think it's a good mechanism? Caitlin, we'll start with you.
Yeah, I think there's still value in it. So I think you look back to, what's the type of claims that you're subject to. For us, the class action really is the most difficult one to deal with. So I value the arbitration agreement for my class action waiver. I'm in a class action right now in California that will probably get appealed through to the Supreme Court. So the amount of time and money and business expense in terms of personnel and documents you're pulling to defend that class action, when I could be subject to a bunch of individual arbitrations that make it much less sexy for the plaintiff's counsel to keep suing us. That's really the value in my arbitration agreement, and it has been for years and years. So even though you value the class action waiver, you want to develop and evolve and really recognize that the mass arbitration is a true issue, but I'm going to keep that arbitration agreement going.
Yeah, I don't know that I can say it much better than Caitlin, but the amount of money I'm sure that we've saved over the years just with the class action waiver, one or the other. So I think there's still tremendous value to having a mandatory arbitration provision, but it's really, again, as Caitlin said earlier, looking at yours, making sure that it works for you, and especially as the landscape has evolved over the years to being less concerned about the unconscionability claims, from having to have it overly, in my personal opinion, only consumer friendly, to something that really works for you and deters people who are out there targeting these exact scenarios. That I still think there is tremendous value to them, as long as it's not a template that you're using, or it's something that is working for you and has all the considerations that you would want in it.
Yeah, because I think that's key. Leah and I both have given examples of how we're using the arbitration agreement actually more affirmatively. And so I would really, if you have not reviewed yours, even in the past couple of months, you should really look at it, because you can do pretty interesting things with it now and not get in trouble, like Leah's saying, to challenges in court. Also think that Texas is trying to emphasize this, because right now we have tornado sirens going off. So maybe that's just my main point, that listen, this is a big deal. This is not just some other agreement that your company should ignore. There's true value in this.
Well, we'll let Caitlin get to cover and end it there. Zach, anything that you want to say before we turn this off and take a break?
Well, I want to thank you. I want to thank Saul for putting this together. It's great content. And I want to highlight one case that's coming down the pike. It's Walrich, Wallrich versus Samsung. They're duking it out about mass arbitration in the Northern District of Illinois, where Samsung, in response to 100,000 demands, said, we're just going to not pay the AAA. You can't do this in California, because in California, there's a statute that says if you don't pay your arbitration dues, you're put to death. So they can't do it in California, but this is all Illinois customers. They said, we're just not going to pay. We're going to waive our right to arbitration. And if the consumers want to pay the arbitration fees pursuant to the AAA rules, they can, and will engage in arbitration, but they're not going to, because that's the entire threat. And so the consumers moved to compel arbitration and moved to compel Samsung to pay the arbitration fees in court. And they're battling it out. And that will be, I think, the most interesting case on mass arbitration to date when that decision is issued. So be on the lookout for that. Thanks, Ryan.
That's great. Thanks again, everybody. Thanks, Rich. This was a really interesting panel. We're going to take, let's just take an 11-minute break. We'll come back at 10:50. But thank you again to everybody. And our next panel will start at 10:50. Madeline, can you advance to the next slide? All right, thanks everybody. We're going to go ahead and jump into our next presentation. We're going to talk about some recent developments and issues in Fair Credit Reporting Act litigation. We'll discuss some litigation trends and certain issues that continue to give clients challenges, such as ID theft and fraud. I'm also thrilled to be joined by Justin Bradley, Deputy General Counsel for Litigation at NewRes and ShellPoint, and he's going to provide a great in-house perspective on how he and his team are dealing with those cases. So next slide, we'll dive right into it. We have our second code here, so please make sure to write this down. It is 54902. It's at the bottom of the page. 54902. Please make sure to record it and save it, and then you'll have to report that back to us. So like past years, FCRA cases and filings continue to increase over the prior year. Specifically, FCRA cases have increased by more than 4% this year. However, I believe this figure, which comes from Web Recon statistics, is actually underreporting the increase. And that's because these figures don't include arbitration filings and pre-suit demands. And as we discussed on our last panel, we have seen a significant increase in arbitrations and demands brought by consumer repair organizations and the consumers themselves seeking to cure certain alleged issues with their credit reporting. In addition to the litigation and pre-suit demands, FCRA compliance continues to remain a primary focus of the CFPB and state regulators. We heard from John Redding and Trip Riley today on the CFPB's recent consent order involving Hyundai Capital, and we will discuss the CFPB's circular that was issued about 4 weeks ago on certain of these issues, including ID theft and fraud. Next slide. So while these cases are a thorn in many clients' sides, there are some early indications that courts may be beginning to tire of these claims. Specifically, I have seen courts begin to push back on some of the hyper-technical violations that are being brought by consumers. And courts have also seen much more willing to dispose of these claims on motions to dismiss than they ever have in the past. And that's a really great development for the defense bar that we hope continues. The Bibbs decision out of the Third Circuit highlights kind of a more common sense approach that courts are beginning to take on reviewing these types of claims. In Bibbs, the plaintiff's claims involved loans that were closed with balance transfers, but included a reporting of the pay statuses, which indicated that the loans were more than 120 days delinquent. Now, the creative plaintiff's counsel argued that this was inaccurate because it reflected the current state and status of the loans. However, as most of you probably know on this webinar, the pay status notation is actually a historical notation that reflects the payment status of the account at the time it was transferred or charged off, and is not a current reflection of the account status. The lower court granted TransUnion's motion on judgment of the pleadings at a very early stage and correctly found that the pay status notations were only historical references and could not have caused any harm to the plaintiffs. On appeal, the Third Circuit discussed the appropriate standard for reviewing the accuracy of reports and held that it must use, quote, a reasonable reader standard to determine the accuracy of a report and make such a determination, and this is the most important piece of this decision, make a determination by reading the entirety of the report, and not in isolation, but the report in its entirety. The Third Circuit upheld the dismissal of the plaintiff's claims on a judgment for the pleadings, finding that just because a report could potentially be a bit clearer doesn't mean that it's not very clear at present. And the report contains multiple conspicuous statements reflecting that the accounts are closed, and a reasonable interpretation of the reports in their entirety is that the payment status of the closed account is historical information. So the primary takeaway from this important decision from this year is that it's the Third Circuit's affirmation that the entire report must be reviewed in determining the accuracy of a consumer's reporting. Now, we've seen a number of claims arising from reading a certain item in isolation, such as whether or not a balance is zeroed out on an account that was discharged in bankruptcy, or whether or not a monthly payment was zeroed out after the account had been charged off. This standard that's now going to be used going forward, that requires the courts to look at the entirety of the report, will make it much more difficult for plaintiffs' counsel to pick out certain reporting items in isolation and try to manufacture some inaccuracy or some uncertainty in the reporting. Next slide. Next, I want to address a claim that I believe represents one of the most difficult cases currently in the space and presents some of the most significant risks. And these are claims relating to ID theft and fraud. One of the many challenges with these cases is that the FCRA doesn't establish bright line rules or guidance on what a reasonable investigation is, what furnishers have to do when they receive these disputes. So clients, courts, and juries are left to interpret this very difficult standard. So in reviewing some of the recent decisions, examining what a reasonable investigation is, there are a few takeaways that can be gleaned from some of these decisions dealing with ID theft and fraud. The first is, it's clear that in most instances, simply comparing a consumer's personal identifying information to the information in your file is unlikely to be a reasonable investigation under the FCRA. And this makes sense because a consumer's information consumer who claims his information was stolen or his ID has been stolen is of course going to match the information that's contained in the file. In almost all instances, a cursory review and comparison of a consumer's personal information to the information contained in your file is going to be insufficient for purposes of discharging the reasonable investigation standard for these types of claims. Second, it's a very high bar, as I'm sure many of you know, to succeed on summary judgment and establish that your investigation was reasonable as a matter of law. And the difficulties on succeeding on summary judgment means that it's essential to undertake early case assessment and analysis at the very beginning of the filings. This is key to avoiding long, protracted litigation on these issues, and we're going to discuss, how we as outside counsel undertake this analysis when we get cases assigned to us. Next slide. So I'm not going to spend a lot of time discussing these cases because of time constraints, but I did want to include them in the materials for your reference. As I indicated, they highlight the two primary takeaways. The insufficiency of this cursory review of a consumer's personal information and the difficulties in demonstrating a reasonable investigation on a summary judgment motion. Next slide, please. So when your team gets one of these cases, we begin with a few basic steps to help us assess the risks and drive the strategy going forward. First, we look to see who it is that's bringing the case. I think Caitlin mentioned this on our last panel. It's essential in these cases in the FCRA space to know your adversary. Each of the plaintiffs' counsel that we deal with operate differently, and this information is going to drive your risks, your settlement levels, and what your next steps should be. Some counsel are reasonable. They'll consider early resolution with limited discovery or no discovery at all. And others take a different approach. They won't even return phone calls, make demands without getting some discovery in the door. Knowing who you're dealing with on the other side is going to help drive your case strategy and your immediate next steps. Second, you want to undertake an early case assessment and analyze the facts. This is key to avoiding a long, protracted litigation on these issues. Specifically, you want to identify the bad facts and issues, some of which we'll talk about in a moment. You're going to want to ferret out those facts well before discovery so you can mitigate the risks associated with these facts by pushing for an early resolution where appropriate. The other side of that coin is that you want to identify positive facts, facts that indicate that there's no way this consumer was the subject of ID theft or fraud, and that support your investigation in order to create some leverage with the other side and hopefully drive down settlement demands. Next slide. So over the years, we've come up with a checklist of relevant items to be examined. Now, you can have your in-house team conduct this preliminary analysis, and that's great. We have clients who provide a detailed summary of their findings to us as outside counsel, or you can have your outside counsel conduct this type of review. This checklist can also be used to supplement your existing review procedures, because many of these items really should be considered as a first level review or a heightened ID theft or fraud review. None of these items by themselves are determinative, but you want to examine all of these pieces of information as a whole, because it's going to help you determine at a very early stage whether or not a viable fraud claim really exists here. So the first is an easy one, right? You want to examine the application and origination documents for indicia of fraud. You want to look for mismatched personal identifiers or personal information that can connect the plaintiff to the origination. This can be mismatched social security numbers, an address that's unconnected to the plaintiff, or a primary email that just clearly doesn't belong and is out of place. It should include a review of the underlying applications, and it should review the notes or obligations themselves. The second thing you're going to want to look at is the account information for email, primary telephone, and billing addresses. Look for changes at or near the time of origination. We often find indicia of fraud can be found with near immediate address changes, with credit increases, with primary billing changes, such as changes to a paperless billing. In and of itself, one of these items isn't going to be conclusive, but it can start to create various indicia of fraud or non-fraud that allow the representative, your counsel, your in-house counsel to reach a conclusion on whether or not there's a viable claim here. You also want to examine the payment history. Were payments made prior to a fraud dispute? Track the information to the extent available. We have found this to be really effective, particularly where we can track payments through account numbers or otherwise connect them to the plaintiff. Next, examine your ACDV history, right? You want to examine whether or not there were any non-fraud disputes. So for example, we've seen this in a number of cases where there are a history of non-fraud or account-related disputes, such as challenges to the account balance or timing of the payments. These are submitted before somebody says, this account is not mine. If so, I would say that in those instances, it would be an indicia of non-fraud or a valid account where you have those. Next slide. So you'll also want to pull and examine the call recordings. Now, everybody's on mute, so I can't hear it, but I can hear the collective groan. This is one where I hear from clients that they consistently push back on. The answer to the question of, do I really have to do this, is yes for these cases. We have identified and mitigated significant risk in our FCRA cases by listening to these recordings. We've had cases where clearly the individual calling is a different sex or age than the account number. They even give the wrong name sometimes. These should have been flagged by the representative, and we've been able to mitigate the issues associated with this evidence by pushing for early resolution before ever having to turn over these recordings. We've also had call recordings on the other side that have blown up plaintiff's fraud claims. So it is a really important piece of evidence that we like to listen to and analyze at the outset of a case. Next, you're going to want to examine all previous communications and fraud investigations. Was a fraud investigation previously conducted? Was any new information submitted? Were any conclusions reached? It's important to ensure that you make sure there aren't any open fraud investigations at the time of the response, or worse yet, a conclusion of fraud from one department that wasn't seen by the reviewer. This is a real bad fact case that we defended, and we were able to identify this determination of fraud early on that the reviewer simply couldn't see, and we resolved it before discovery. But it's important to get these facts to your counsel and for you to ferret them out before discovery process. Examine the ACDB attachments. police reports, and fraud affidavit. The details or lack thereof in these documents are important. Police reports or fraud affidavits, which identify the dates of the fraud, the suspect, or other specifics, should be taken seriously. ID theft affidavits, which identify dozens of accounts that are not the plaintiffs, do not have the same force. I've had cases where a simple call to the investigator revealed that the extent of the fraud, which the police were actually prosecuting, and the viability of plaintiff's claims. We moved quickly to resolve that one shortly thereafter. And so that's an important piece of the puzzle. The next one is run a people map or Lexis or some other third-party search on the plaintiff and the relevant parties. Compare phone numbers, addresses, email information, and relatives information to the plaintiffs. Most of the plaintiff's counsel will provide additional information, but only if you request it. Most plaintiff's counsel will give you where the plaintiff lived, what his telephone numbers were at the time. We've used these third-party searches to identify plaintiffs who are actually using aliases to claim fraud and have gotten claims voluntarily dismissed based on these searches and the information that it's led us to. Examine previous investigations and the reasons for the response. You want to understand what specific items the reviewer looked at and how these conclusions were reached. Next slide. So summarizing, what steps can you take to avoid these claims? First, ensure proper compliance on the front end and of direct and indirect disputes. Second, monitor and confirm ID theft disputes are escalated. These disputes have a higher level of risk and should be treated as such. Third, flag attorney letters and track filings. When an attorney submits a dispute or pre-litigation demand, pay attention to who it's coming from and how often they turn into lawsuits. You can and should be heading off some of these disputes at a pre-litigation stage before outside counsel ever gets involved. Fourth, document the investigation. This is a really important procedural issue that I do not see enough clients doing. You want to document the investigation itself, not just the procedures. This is an important step to the review process, and you should implement procedures that document what steps and what documents were reviewed for each review, and whether that's in notes or descriptions in the account file or checklist of documents that are reviewed. It's much better to provide your outside counsel with, here is what this specific reviewer did for this specific review, rather than just giving me a policy that says, this is what they were supposed to have reviewed. Because your reviewers aren't going to be able to recall one of 10,000 reviews or disputes that they've looked at in the past 3 years. Finally, an issue that continues to repeat itself are issues of familial or relationship fraud. This is where a family member, a roommate, an ex-girlfriend, or a boyfriend is the alleged fraudster. Because these are becoming so persistent and consistent filings, we are currently discussing more aggressive strategies that pursue whether or not to pursue the family members, the fraudsters, as a means of dissuading these claims. So those are just some high-level things to focus on as you look at your procedures. I want to talk about one regulatory circular that was provided by the CFPB that dovetails with these claims. It's CFPB Circular 2022-07, and it addresses the reasonable investigation of consumer disputes. One of the primary questions raised by the CFPB in the circular was whether consumer reporting agencies and furnishers were permitted to impose obstacles that deter submissions of disputes. Unsurprisingly, the CFPB answered no. Specifically, the CFPB found that furnishers can't evade obligations to investigate disputes by requiring consumers to submit particular items of information or documentation with a dispute before the entity will actually conduct its investigation. Now, look, I know that this seems like it's self-evident, but I've had this same question arise multiple times in the context of ID theft and fraud investigations, where clients want to request missing pieces of information like police reports or fraud affidavits prior to undertaking the investigation. It's always been my recommendation that you cannot do that. And the CFPB has confirmed in its circular from last month that that is in fact the case. They've confirmed that furnishers cannot and should not require any additional information or forms to be submitted by consumers prior to undertaking the reasonable investigation. Instead, furnishers should review the information that they have available to them to conduct these reviews and make the determination based on that. One of the other significant developments was the CFPB's recent consent order in the Hyundai Capital matter, but John Redding already did a great job of covering that earlier this morning. So at this point, I want to bring in Justin Bradley to provide kind of this really important in-house perspective on these claims and the challenges of these claims. So Justin, just to level set us here, what has your team seen in recent years with these cases, and what overall trends have you observed?
Yeah, thanks, Ryan. So our litigation trends, as you mentioned, really across the industry have certainly gone up. Now, for us, a lot of that increase happened last year. So as we went from 2020 to 2021, it actually was about a 200% increase. What I'm talking about there is both pre-litigation threats and actual litigation being filed. When we saw that increase, one of the things that we did right away was go ahead and assign an attorney on our team that can review those pre-litigation threats that are coming in through our complaint team and start to handle those just like we would any other type of early resolution on litigation that's coming in. So that increase really happened for us during that 1 year time period. So far this year, we're looking at about a 5% increase. And just for context, overall FCRA litigation is about 5% of our portfolio. It fluctuates between 5 and 10% of our litigation portfolio. So it is a significant amount of our litigation. It is something that, certainly we see a lot of very similar issues that are coming up within those particular matters. But a lot of that increase really came up post CARES Act.
And so can you talk a little bit about your overall strategy as the manager ahead of the litigation for Shell Point and New Res? What's your strategy to you and your team for how to deal with these cases?
Yeah, the important part for us is that our overall litigation strategy is doing a root cause analysis on every file that comes in the door. That's just a fundamental part of our litigation strategy. Litigation by nature is always going to be reactive, and we know that. And so for us, it's a good opportunity just to gut check and see if there are processes that we can change, what things are driving litigation. Maybe we're compliant, but the cost of defending this overall practice over and over pushes us towards adjusting it to be maybe a little bit more consumer friendly in some areas, or addressing processes a little bit differently, or working with training with different consumer service folks to be able to do that. So that's part of our fundamental litigation strategy. What does that look like for FCRA cases? A lot of that is working very closely with the reviewing team that is receiving the disputes. And we have a very low definition of complaints. For us, a complaint is any expression of dissatisfaction at all. And so when those come in that deal with credit reporting, there's a very focused team that receives that. So it doesn't have to be a formal ACDB that's received. It can be, even something as basic as a verbal complaint saying that something's wrong on my credit report. And so we start that process of looking at, okay, what was the complaint process? We went through with our team to try to give them training and access to the complaint team systems. We have a separate complaint tracker that has access to not only the content of the complaint, whether it's verbal or written, but also all of the information that went into the actual response to that complaint. The content of the response, the review that was done, all of that is stored within our complaint tracker. And so giving our team access to that so that we can go ahead and start reviewing the history and start getting up to speed initially and look for those issues that we may see in the case right at the beginning stages. A lot of that is collaborative with our outside counsel. We're not subject matter experts. We try to centralize these as much as we can with a national counsel, so that we can really have someone outside that understands our processes, really understands the players, understands who we're going up against, and can help us navigate through that. Internally, a lot of our structure is based on specific third-party client portfolios. And so the team itself may not be the subject matter experts for credit reporting. The piece that is important for me when we're talking about these cases is that a lot of times many of these cases can be resolved with nuisance value settlement. And we end up having a lot of success resolving these at a very early stage with nuisance value settlements. However, and I should say, we are willing, Ryan, as you mentioned earlier, there is some risk in modifying accurate credit reporting. If we feel like the reporting is accurate, we're not going to do any type of modifications. We're not going to delete the trade line. We're never going to delete a trade line for a consumer that we have a continuing obligation with going forward. But if we have obviously, if we did something wrong, we're going to fix the credit reporting. But if we have an issue that is a legitimate dispute, and the example that always comes to mind is a payment that was sent into a prior servicer, loan transfers to us for servicing, and there's a legitimate dispute over whether that payment was sent to the prior servicer. Maybe it was right around the time of the service transfer. Maybe the prior servicer can't locate that payment, but you have a genuine dispute over whether that payment was received and should have been forwarded to us. We may look at doing some suppression for that 1 month of credit reporting that is reported as negative. But that's going to be something that we need to review and get to the bottom of the actual issue in the disputed credit reporting to actually get to that point to say, is there something that we feel comfortable doing with some type of minor modifications or suppression on the credit reporting there. The other thing that is really important with the actually getting to the data and getting to that root cause on these cases is that many times the credit reporting team, at least for us, they're generalists, right? They're going to be handling credit reporting disputes that touch on a lot of different aspects of the business. And for us, that could mean an account that is being serviced during bankruptcy. That could be an account that is in the middle of a forbearance or other loss mitigation. Could be an account that just service transferred in. Might be a performing account, maybe escrow issues involved. There's a lot of different aspects of the business, and understanding that the reviewers are not necessarily also going to be the subject matter experts for all parts of that business. And so something that we've done a lot is a lot of training with that team and working with them to make sure that they're doing the investigation that's really going back, right? You can't just say that the reporting is accurate because it reflects what our system reflects. Well, of course it does, right? It's going to reflect that. And so instead actually looking at it and saying, well, if this is an account that's in bankruptcy, for example, actually working with the bankruptcy team, maybe working with your bankruptcy outside counsel as part of that process to make sure the account status is showing correct based on what the actual plan payments might be, for example.
Yeah, I think you hit on a couple important topics that I want to highlight. I think the first is the root cause analysis. So for all of you listening, like that is really an essential component. And as outside counsel, I feel like that's where your outside counsel can really bring value. Make sure your outside counsel are not just defending the case in front of them, but looking for compliance holes, right? Is there an issue with the way in which the reviewer undertook the reasonable investigation? Are there improvements that can be made? Is this a larger issue? So it sounds like, Justin, you and your team are doing that, and that is really a terrific approach to avoid the next few cases, and then it doesn't turn into some sort of systemic issue. Because here in New Jersey, I can tell you another mortgage servicer has been hit with probably 60 to 75 of the same exact cases. And when a plaintiff's counsel or credit repair organization find it, they sign up people, and they will hit you over and over and over again. It's like death by 1,000 cuts. So it can be really the best approach is to try to get out in front of these issues and do what Justin just said. I think the other kind of interesting component that I'm beginning to see a shift into either a national or co-national counsel approach. It reminds me of similar when the TCPA was really, hot, that you would have only a few counsel who handled those nationally. And I think there's real value to that, because your outside counsel get to know your internal policies and procedures so well, right? You get to know that this client does things in this way. Frankly, you may know that there's a problem with the ID theft procedures, and you can look at the timing of the dispute and you can say, oh, wow, this is when they were sending these overseas. And this is an area that I know this probably wasn't done as well as it could have and should have been. So there's real value, I think, in taking that approach. And I'm seeing more and more clients undertake that structure. Justin, are you using any alternative fees for these cases, and how have those arrangements worked for you and your team, if so?
We are. I think these cases in particular are really ripe for an alternative fee, for the primary reason that a lot of the claims themselves are very similar. The facts are really what differs. But ultimately, your defenses, having a national counsel that can understand your processes can certainly add efficiencies there. And having your team, understanding the information, being able to get that information to counsel very quickly so that we can have hopefully some potential early resolution on these cases is, certainly working very well for us. So the model that we've done is really just a traditional fixed fee for these cases. When they come up, we recognize there are going to be some cases that we need to move out of the fixed fee because they're going to go past summary judgment. They may have some unique issues there, or a particular opposing counsel that we know is going to be very difficult to work with. But for most of these cases, I think we're able to really work under the fixed fee model and resolve these. And again, having that relationship with counsel, I don't think this works for a fixed fee model that's going to be with 50 different counsel that are handling these cases around the country. It really is having a national counsel that has a good footprint and can address these cases and understand your process works really well. And the example that I'll give is, to your point, Ryan, that you just made, having a national counsel that understands your business really as well as you do internally, or has gone through the fire with you on a few of these cases. We had probably like everyone, we had a volume of complaints and written communications coming in really at the start of the pandemic, right? Nobody really knew what was going on, a lot of questions, a lot of information. And so our written correspondence team was just flooded with information. And so that meant that our overall volume of complaints went up. And so during that time, we had to staff up with a number of temps. We had to bring groups from other departments. A lot of our foreclosure team, just because foreclosures were on hold due to the moratoriums, came over and started to help with that. And so this was a lot of individuals that needed to address a lot of things. Many of them didn't have, as much as we did training and tried to address it, they just didn't have as much experience as our dedicated team. And so we had a few complaints that as much as we would have loved to have gotten to the dedicated credit reporting group, just were missed. And so because of the volume that was coming in, they were just indexed correctly wrong in the system. The wrong task was open. It was a innocent error by a temp who just didn't have the right experience to understand that this is really what this was going to, and we needed to direct it that way. And so, of course, a couple of those resulted in litigation, and having counsel that understood the overall volume of correspondence that was coming in at that time and could see that was happening in that particular window, understood that these really were one-off issues with wrong indexing, and here's what our normal processes were, and being able to help us to get to the root cause of that very quickly to get to quick resolutions. And so under the alternative fee, we were able to predict, okay, we see this increase coming. We know what the volume is going to be. Now we've got predictable spend. Certainly allows my general counsel and our CEO and our leadership team to know that these cases are not going to break the bank, but also know that we've got a good process to address them and get quick resolutions on it. And I think the fixed fee really incentivizes that.
Yeah, I agree. I mean, I think that these cases are almost perfect for a fixed fee or almost a modified fixed fee where you can do it in phases, right? Because I know that certain clients get uncomfortable with the idea, right? The idea that maybe somebody's going to get a windfall, right? The law firm's going to bring these cases in and you're going to end up settling everything within the first 2 weeks and get a windfall. But that's not a real good fixed fee if that's how this shakes out. So the way that we kind of address that situation is, we keep our time where we have these types of arrangements. So we're going to continue to keep our time as if we're billing on an hourly. And then in 6 months, we're going to share it, right? 6 months to 8 months, wherever we feel like the time is that you can get, you can really see these cases through the entire progression, because the outliers are going to bring down the average, right? Or bring up the average. So you have to have kind of a collaborative approach for these to work with your outside counsel. You don't want your outside counsel, I would say, losing tons of money because they're spending, they're set at 15 grand, but they're actually spending 50. Like, that's not an ultimate viable solution. So, what we try to do is make it collaborative and share what the billings are after 6 months. And I think it's a really good way to make sure that you find that sweet spot with your counsel to where you're giving Justin the predictability and that they're looking for, but also the firm is getting compensated for the work that they're doing. So, I think these cases are repeat. I mean, we see a lot of the same ones and they resolve in very similar timeframes. And the outliers aren't really what they used to be. So, it's something that I think is kind of perfectly situated for an alternative or a phased approach where you're doing it, initial case assessment and response on one fee, discovery on another fee once you hit that date, and then summary judgment would be another fee. So you can kind of tier it in that way too. Justin, from a substantive perspective, you mentioned CARES Act. Are you seeing the increase in any particular types of disputes or claims?
Yeah, I mean, CARES Act is certainly the driver. I think a lot of what we're seeing is post forbearance credit reporting. We've tried to follow industry guidance around doing step up reporting post forbearance, but there are some unique facts that come into play with some of those situations. The one that certainly comes up quite a bit is a borrower who has a 12-month forbearance, and towards the end of that 12-month forbearance, finally starts to apply for a loss mitigation solution at the end of that. And so, you have a borrower who has been reported current through the forbearance, and their loss mit solution that's going to bring them current may be still a few months. They may have to do a trial period plan for 3 or 4 months post forbearance. And so what do you do with the credit reporting during that time period, right? That's something that we have certainly scratched our heads a bit about, and has certainly resulted in, some litigation claims that we've seen. But really around forbearance has been the primary driver. The other issue has been post-bankruptcy credit reporting. And the thing that I would say with that is, it's very critical to make sure that you understand, as in-house counsel, as outside counsel, what are the bankruptcy procedures there? What are the controls that are in place to make sure that the payments through bankruptcy, particularly in a Chapter 13 plan, are being tracked and applied correctly? What is the status of the loan when it comes out of discharge? Are you doing discharge reviews to make sure the account status is correct before you just release the account into normal servicing? All of those factors can result in inaccurate reporting post bankruptcy discharge, and that's where we tend to see a lot of particularly pre-litigation claims around.
Yeah, I mean, there's been just a ton of post-discharge filings in the Third Circuit in our footprint, a lot of which is around the failure to zero out a balance where you are post-discharge. There are a couple firms that have kind of taken that up, but those claims, I would say within the past year to 18 months, are getting dismissed on a motion to dismiss. So that goes back to the kind of Third Circuit case where courts I'm seeing for the post-discharge reporting are looking at the report as a whole. So if the report is saying that there is reflecting that it's been discharged, no one can really review the balance in isolation to say, oh, this is still a current balance. So courts are really, that there is that shift that I'm beginning to see, and I hope we see more of, where courts are taking a real common sense overall approach to what the credit report looks like and not looking at a specific item in isolation. Because that's certainly been fodder for the plaintiff's bar on those bankruptcy cases. Justin, just a couple more here. I mean, are you using any AI or any technology to help streamline or expedite reviews yet? Is that something your team has looked into?
It's definitely something that we're looking at. The hard part with this particular type of claim is that it's very fact intensive, and so there requires to be a lot of review of the account itself and all of the factors that go into that. The one area where we've had some success outside of the FCRA that I think is applicable here is with TCPA compliance. So we saw a taper off of TCPA related litigation years ago, actually before a lot of that happened across the industry, because we implemented some AI related, technology related tools around speech to text for consent revocation. And we were able to focus on that. And the factor that I want to mention with that is we recognized there was an opportunity to say, you know what, our consent revocation, being able to have a rep who's on the phone, update the account and document consent revocation, relied on that individual to be 100% of the time, right? There's no room for error there. If you miss the revocation and then that phone number continues to be on the dialer and you continue to see multiple calls out to them through a dialer campaign, you've missed it already, right? And so we don't want to rely on somebody being 100% of the time. I'm never going to be that, right? We're all human. We all have bad days. And so instead, let's try to really help to augment the reps to have some controls in place that are backstops, right? And so what I would say on that is, things around credit reporting that we've been thinking about are, payment application, right? Having, payment application rules, revisiting those, looking at your exceptions to your payment application rules, understanding, things that are ultimately going to go into the credit reporting, and how can you help to have exception reports so that before you report that, you've had somebody that has reviewed the exceptions. At the end of the day, if everything's an exception, if everything's a manual process, you're never going to be able to catch everything. But if you can identify and have really good controls around identifying those exceptions and then have those reviewed the way that we did it with consent revocation calls, having the technology identify those exceptions and then having a rep actually review those to be a stopgap control has certainly helped us to reduce litigation in some key areas.
Yeah, and I don't think we're getting to a point where this process can or should be fully automated, right? Like regulators are never going to want to see that. We're not ready for that yet. They're not ready for that yet. So it's a reasonable investigation. That's not something that can or should be automated. But I think to your point, there are tools that can be used to help streamline the review, because that's always the balance, right? You want to undertake a robust review in order to discharge the obligation for a reasonable investigation. But you also have to conduct your business, right? So that's something that we often get involved with clients. And I think the technology that you mentioned on the TCPA front, where it clips the relevant words that are used and you can search the recordings for relevant words, is an area that I think is really interesting, because I think, it takes so long for a reviewer to listen to call recordings, right? But if you can kind of pre-wash or pre-scrub those call recordings and only give them the portion of the recording that highlights specific words, and I'm thinking about like fraud investigations, right? So you put in terms like fraud or ID or theft or things like that. I think that can be an area where that technology you're using and other clients are using can be really effective to give a reviewer more robust tools just to allow them to do it on a quicker basis. So that's something that I think that clients are going to continue to use, and I would encourage everybody to continue to explore, because if you can make your reviews more meaningful while at the same time allowing them to be done faster, it's a win-win. It really is. So Justin, we're up against it. Anything else for the good of the group that you wanted to mention before I turn it over?
No, Ryan, I think you covered it. I appreciate it.
Well, thanks so much. I really, really appreciate you participating. I think your perspective was a really important one. So I think at this point, we're going to turn it over to our last panelists, Jim and Kelly, for our class action update. So take it away, guys.
Thanks, Ryan. Appreciate the introduction. So Kelly and I are going to run through what's happened with the TransUnion versus Ramirez case in the past 18 months since the Supreme Court came down with that decision, and what implications does it have for consumer finance class actions. And most of it is very good news for us defense counsel. So let me start with just an overview of Ramirez. If we could flip to the next slide. So Ramirez was decided by the Supreme Court in June of 2021, and the Supreme Court there vacated a jury award against TransUnion in favor of a class in the amount of $60 million on the ground that many of the members of the certified class did not actually meet their burden at trial of showing an injury caused by TransUnion's inaccurate designation of them as specially designated nationals or individuals who threaten America's national security. The facts for the plaintiff, who was the class representative, were pretty strong. He actually was shown to have suffered injury when he was turned down for financing to buy an automobile because of the erroneous designation in his credit file that he was a terrorist. The trouble was at trial for the class is that TransUnion never disclosed to any third party these false designations of class members as terrorists to the majority, in the case of the majority of the class members. So you had a situation where they went to verdict without evidence that each of the class members had actually suffered some financial, reputational, or other injury that was cognizable in the law. The trial court had concluded that the jury verdict was fine, but the Supreme Court reversed, saying that, in the words of Justice Kavanaugh, if there's no concrete harm, there's no injury. And what the court explained about that was what Ryan mentioned earlier, which is that a consumer finance company that technically violates the FCRA, but that violation does not cause actual harm to the plaintiff, or in this case, members of the plaintiff class, then they lack Article 3 standing to actually bring their cases before a jury in federal court. Huge ruling with lots of consequences. The court did not, however, decide in the decision whether every class member needs to be shown to have suffered concrete injury or thereby have Article 3 standing at the class cert stage. So that is percolating through the circuit courts of appeal. I suspect in the next year or two, we'll see a case go up on that issue to the Supreme Court. But what's happened since then? Well, what's happened since then is that defense lawyers have cited TransUnion versus Ramirez in more than 25 jurisdictions in more than 40 cases for the proposition that there needs to be at least a showing in a damages class action of a methodology that the plaintiff class can use to establish injury for each class member. And lacking that kind of methodology, a class should not be certified. This has come up in a variety of claims under, obviously, the FCRA, ERISA, RESPA, as well as antitrust, product liability, false advertising, privacy, insurance, and wage and hour claims. And it's a mixed bag. So Kelly and I looked at cases over the last 18 months. You could flip to the next slide. So some courts have held that, Ramirez means that if the class representative himself or herself cannot demonstrate concrete injury from a violation of a statute or common law right, then the case cannot proceed. An example of that is from an insurance case called Smith versus Golden Rule, where the court denied the motion for class certification, where the plaintiff could not show that he had actually suffered an actual injury from the alleged breach of the insurance policy, because the damages he sought either were not covered by the policy or fell within his deductible, and therefore there was no injury. Pretty straightforward application of the TransUnion case. And in this case, the plaintiff didn't get even beyond the class cert stage because of his own lack of concrete harm. Flip to the next slide, please. As I said, it's been a mixed bag. So some courts have held that as long as the named plaintiff can show that he or she has suffered concrete injury and has standing in Article 3, it's enough to certify a class, that there's no requirement, because TransUnion didn't address the issue of whether all class members need to have injury at the time of certification as opposed to the time of trial. So in the Butella case from the Western District of PA earlier this year, court granted a motion to certify a FDCPA class, despite defendant's argument and some evidence that there was not injury amongst all the class members, where the conduct at issue was sending correspondence to the customers who had defaulted on their credit card payments that a judgment could be entered against them. In any event, the trial court there granted class certification, holding that the unnamed members of the putative class do not need, at the class certification stage, to establish that they have actually been harmed by the defendants, in this case, sending correspondence that didn't comply with the law. Next slide. In some cases, courts recognizing that a class cannot proceed to trial, where some members of the class, even according to the damages methodology, the injury methodology of the plaintiffs, will not be able to proceed to trial because they haven't had actual injury. Courts have basically rewritten or blue penciled proposed class definitions and certified classes, albeit not the class that the plaintiff sought originally. So in Shields versus State Farm from the Western District of PA earlier this year, the court granted class certification. The claim was that the insurance company was undervaluing total loss claims. And the court said there's a problem because even under the methodology of the plaintiffs, some class members did not suffer economic harm of any kind. Namely, their total losses were not undervalued, according to the plaintiff's own theory of injury and damages. And so what the court did is it just cut them out of the class definition and basically rewrote the class definition for the plaintiff's lawyers, certified the class, and allowed the case to go forward. Very interesting way of proceeding, but pretty consistent with Ramirez versus TransUnion. Next slide. Other courts have taken the TransUnion to mean that as long as there's some plausible basis for holding that all class members have been injured by the defendant's conduct, a class can be certified. So again, earlier this year in a RICO case involving Howard Bank in Maryland, the court certified a class of bank customers challenging alleged kickback scheme. And the court, interpreting TransUnion, said there only needs to be some admissible evidence of injury for each class member at trial, not at the class cert stage. And it was enough at the class cert stage that the plaintiff proved that she herself suffered Article 3 injury, and that it was plausible that all class members suffered the same injury. Now, how you can square that ruling with some of the other rulings we've mentioned, I don't think you can. But this is an illustration that courts are wrestling with this issue at the class cert stage and exactly how to set the standards, which is why we expect the U.S. Supreme Court in the next 2 or 3 years to take this case up. And then next slide. There have been other courts that sort of taken the opposite approach to the Louisiana District Court that certified the class after modifying the class definition, and have said that's not within our province as the court, and we're not going to allow the plaintiff to amend it. She had a chance to remove class members who were not injured, who didn't pay the improper fee in this case, and therefore she's barred from moving forward with class certification because the definition she proposed for the class included people that didn't pay the fee at issue. Next slide. And then finally, and most encouragingly for us defense lawyers, there have been a series of courts that have held that class certification is not appropriate and should be denied in the case where it is clear that the plaintiff's proposed class definition includes individuals who did not suffer any kind of concrete harm. So in this Iowa case from 2021, court denied class certification in an FDCPA class where the plaintiff had stipulated to dismissal of her claim because the collection letters caused her no concrete injury. Court did not allow a substitute or replacement class representative to be appointed, and the class cert was denied, case over, both the class case and the individual case. Next slide. And then in other courts following sort of consistently with that have dismissed cases outright where it's clear that while there were false statements made, they led to no injury to the plaintiff or members of the class. And in those cases, the court said, Article 3 standing is critical to being in federal court under the Constitution. And therefore, we don't have jurisdiction to hear this case. So that was the result in the Rodriguez-Ocasio case. And in the Sandoval Midland funding case from just a couple months ago, the court dismissed the case after granting summary judgment and found that the plaintiff lacked Article 3 standing, where the only harm that was alleged was a statutory violation or a statutory harm, as opposed to a real life concrete injury of the type that the Supreme Court said in TransUnion is required. Next slide. So I'm going to turn it over to Kelly, who's going to go through some of the specific areas of the law where TransUnion is being applied. But before I do that, obviously TransUnion has been a boon to consumer finance companies embroiled in class litigation. It adds yet another obstacle under Rule 23 to certification of a class. And many defense lawyers who've had their clients certified a class against them have moved under TransUnion with some mixed success in getting classes vacated after the fact by citing TransUnion. So it's an important tool in the toolbox for in-house counsel. And it really raises the issue in a particular case, depending on the claim, what is the evidence of harm to the class representative and the class that she seeks to represent? Is she just claiming a statutory violation without any real injury, or is there a real injury? And in fact, what is that injury? Is it an informational injury? Is that sufficient? Is it emotional distress? Is it loss of money? Or in the case of privacy and related class actions, did the violation of law lead to the disclosure of the consumer's financial information to others who were not authorized to receive it? Any event, very fun time to be a defense lawyer in this space. And TransUnion, as I said, is a very powerful tool that council should be using aggressively at the motion to dismiss and at the class cert stage. So let me now turn it over to Kelly to walk us through some substantive areas of the law.
Thanks. So the serious constitutional standing obstacles that are presented here don't even just apply to class actions. They also apply to individual actions in federal court, and particularly the claims seeking statutory damages. Like Jim said, under the Fair Credit Reporting Act, the Fair Debt Collection Practices Act, the Truth in Lending Act, the TCPA, and RESPA. Many of these claims reflect a real disconnect between the injury in law, which is the alleged violation of the statute, and the injury in fact, which would be some monetary, reputational, or some other form of concrete harm that's in close relationship with a traditional harm that was recognized as providing a basis for Article 3 standing. And just to point out that per TransUnion, this Article 3 standing also has to be demonstrated in all requests made for declaratory judgments. So we took a look at a high-level survey, because these cases are coming out every single day in these spaces, under the statutes that we deal with most frequently, as to how the TransUnion issue of standing is being applied. So first, if you could switch the slide, please. Under the Fair Debt Collection Practices Act. So informational injuries involving misrepresentations might confer Article 3 standing. And in TransUnion, the court noted that an informational injury could arise where the plaintiffs allege that they failed to receive some required information, or that they had received it in the wrong format. But an informational injury that doesn't cause any adverse effect can't satisfy Article 3. So, of course, FDCPA cases frequently present these issues, and the case law is probably developing quickest as to what the adverse effects in an FDCPA case would be that would satisfy the Article 3 standing. And it's pretty clear that confusion alone is not enough. The District of New Jersey has been almost daily dismissing FDCPA cases for lack of standing, where the plaintiff is just generally alleging that the least sophisticated consumer would be confused by the contents of the letter if they don't plead any additional facts regarding actions or inactions that they had taken or didn't take based upon the receipt of that letter. These courts are holding that post-TransUnion, an FDCPA plaintiff has to allege a tangible downstream injury resulting from what they're calling a misleading collection letter. The courts are holding that the allegations of just pure statutory violations bear no resemblance to common law actions and therefore don't confer standing. And I haven't found any plaintiffs, attorneys who have creatively connected the FDCPA letter alleged violation with some other common law action where they could link them and say that that's where the harm would result. Courts are finding that omission of information alone in an FDCPA case is not enough. The courts are repeatedly holding that plaintiffs lack standing based solely on information that's not included in a letter that was required by the FDCPA. The Seventh Circuit recently reaffirmed that a plaintiff didn't suffer any concrete harm simply because a letter omitted the notice of statutory rights that you must provide within 5 days of the initial communication. And the Seventh Circuit said there was no concrete harm because even though the plaintiff had not received the notice of statutory rights, she never paid the debt and she didn't rely on the communication. The Sixth Circuit has held similarly, where a debt collector allegedly violated the FDCPA by failing to state its full name in voicemails. The Sixth Circuit said it's a statutory violation, but it doesn't have any common law or historical analog, and that the plaintiff just alleging that they were confused or even alleging that they had an economic expense of retaining counsel, those weren't concrete harms that would permit Article 3 standing. Now, alleged misrepresentations may be enough. Courts are divided where collection letters contain alleged misrepresentations as opposed to omissions. Two cases out of New Jersey with the same judge where the defendant allegedly disguised a collection letter as an informational communication about identity theft, while also allegedly misrepresenting its obligations concerning identity theft. The court found that that was enough of a concrete harm to satisfy Article 3 standing. And then a month later, the same judge in the same court found that misleading information in a collection letter didn't confer standing, irrespective of any additional harm suffered, because the plaintiff had to specifically show detrimental reliance on the alleged misrepresentation. This detrimental reliance is consistent with several other decisions, finding that a plaintiff has to take affirmative action or refrain from taking action that would have benefited him based on supposedly misleading statements, which sort of is tying the FDCPA claim with more of a common law fraud claim. In TransUnion, the Supreme Court took no position on whether or how emotional or psychological harm could suffice for Article 3 purposes. And it's pretty clear that emotional distress usually does not satisfy Article 3's injury requirement. So as with purely informational injuries, courts typically find that emotional distress resulting from an FDCPA violation is not a concrete injury for standing purposes. The Seventh Circuit and the Sixth Circuit have cases that hold that psychological states induced by a debt collector's letter fall short, and that worry and confusion are insufficient to confer standing. District courts in New Jersey, Florida, New York, and DC all agree on that point as well. So it's not unanimous, but it's very clear, pretty clear, that a concrete injury under Article 3 requires more than just generalized allegations of emotional distress. Now, disclosures to third parties sometimes do rise to the level of concrete injury. So certain courts have held that a concrete injury does exist where a debt collector violates the provisions of the FDCPA, which prohibit a debt collector from publicizing a consumer's debt. So in a case from the Northern District of Illinois, alleging a violation of Section 1692 F8, where the defendant printed its name on the envelope and indicated that it was in the debt collection business, the court found that there was sufficient concrete harm to confer standing where the plaintiff's parents saw the envelope and that she had to explain that she was being contacted by a debt collector. The court found that reputational harm that comes with explaining to others that you're in significant financial trouble is concrete enough for purposes of standing. Similarly, a case out of the Eastern District of New York where the defendant allegedly posted a complaint in a collection lawsuit on someone's door was sufficient concrete harm to satisfy Article 3 standing because of the reputational harm that came from third parties knowing about the collection lawsuit. Next slide, please. So under the Truth in Lending Act, we haven't seen that many cases that the court is examining TransUnion in TILA cases. But there's one case in the District of New Jersey that did undertake this examination. It's in Burris, the plaintiff had claimed a violation of 1638F under TILA, which requires lenders and servicers to provide customers with accurate periodic statements. So the plaintiffs cited a discrepancy in the amounts due reflected in their monthly mortgage statements. The TILA claim had survived summary judgment when the defendants filed a motion to dismiss for lack of standing. It's important to note that these Article 3 standing challenges can be brought at any point in these cases. So the court, on the defendant's motion to dismiss, agreed. The court specifically noted that the plaintiff had certainly suffered an injury in law and that a TILA violation is a statutory harm created by Congress, but then they went through what the injury in fact that the plaintiff had cited was to see if it was sufficient for standing purposes. So the plaintiff's amended complaint had originally alleged that the plaintiff suffered a late fee and negative credit reporting, which were injuries in fact commonly recognized as concrete harms in American courts. So if those allegations had remained true, late fees and negative credit reporting would have been found by this court to be a concrete harm sufficient for standing purposes. But on this motion to dismiss, the defendant submitted a declaration of one of its employees who attested that no fees had been charged against the plaintiff and that nothing had been reported to the credit reporting agencies as a result of the arrearages that were incurred due to the allegedly violative statements. So the court looks at this declaration and finds that the concrete harms were no longer available to the plaintiff for purposes of standing. The plaintiff then pointed to the cost to pursue the TILA claim as the concrete harm, and the court rejected that. So the court found that costs incurred to pursue the claims are not enough and said specifically that such costs are just a self-inflicted wound. The motion to dismiss was granted because there's no direct causal connection between the TILA violations and any injury in fact. Next slide. The Real Estate Settlement Procedures Act, how would TransUnion come up in one of these cases? Well, in Board versus Union Savings Bank in the Southern District of Ohio, it was a RESPA case based on failures to respond to notices of error and failures to timely provide the information requested and request for information under Regulation X and TILA. The plaintiff had alleged that the lender's failure to respond to her notices of error had perpetuated her payment of erroneous escrow fees. The Southern District of Ohio indicated that if the plaintiff had paid erroneous escrow fees, that would have been sufficient concrete harm for Article 3 standing purposes. But the court specifically held that the cost of compliance is not a concrete injury sufficient to find Article 3 standing on the RESPA claim, and that the plaintiff's stress, anxiety, and anger were not sufficient concrete injury in fact. So since there was no proof about the payment of the erroneous escrow fees, the court found that there was no standing here. In the case out of Maryland, Brosco versus Howard Bank that we mentioned earlier in the presentation, it's a RESPA and RICO case, so related to unlawful kickbacks. And the court there found that a sufficient concrete injury could be found under RESPA, where the plaintiffs weren't even pointing to any particular overcharge, but alleged more generally that they were injured by kickbacks or referral fees that tend to unnecessarily increase the cost of certain settlement services. So in that case, found under RESPA, the court found that that was enough concrete injury alleged to satisfy Article 3 standing. Next slide, please. Oh, the Telephone Consumer Protection Act. Case law applying TransUnion within the context of the TCPA is still relatively scarce and pretty underdeveloped, but the 11th Circuit, it's, I believe, the only federal appellate court that have analyzed TCPA claims under the TransUnion rubric. They did it sua sponte, and recently they applied TransUnion to vacate certification of a TCPA settlement class because the class definition included members who can never have Article 3 standing under 11th Circuit precedent. And this one was a nationwide class that included individuals who had received only a single text message, which under existing 11th Circuit precedent, that wouldn't be, that they, a single text message wouldn't, single text message plaintiff would not have sufficient standing under 11th Circuit precedent. So at the time of class certification, the class included people who actually would not have standing. So the 11th Circuit looked at the standing of all class members and remanded the class back down for the court to redraw the class and also ask the parties to address whether the plaintiff's receipt of a single cell phone call in violation of the TCPA was sufficient to confer standing, as the issue had been had remained unsettled within courts in the 11th Circuit. Compare that with a case out of Connecticut 2 months ago, where the court found that a single ringless pre-recorded message delivered straight to the plaintiff's voicemail inbox was enough of a concrete injury to satisfy standing, because they tied the TCPA violation to nuisance and privacy invasions that were the harms that Congress was concerned about when enacting the TCPA. Next slide, please. In data breach cases, courts are grappling with whether plaintiffs have sufficient standing to bring suit, notwithstanding lack of actual or attempted misuse of their personal information by hackers. Courts are looking at, when is a risk of future harm sufficient to create standing? After TransUnion, district courts around the country had found that plaintiffs lacked standing where there were no allegations of actual misuse of personal information or identity theft or financial fraud. So they were waiting, basically telling people they had to wait to be harmed before that they would have standing to assert any of these claims related to data breach. But just recently, in one of the first post-TransUnion decisions by a federal court of appeals in this space, the Third Circuit found that a plaintiff in a data breach class action had standing based on the imminent risk of future harm in the form of identity theft. The Third Circuit provided a three-pronged test for analyzing this imminent and substantial risk of future harm for purposes of standing. In this case, the plaintiff had sensitive personal and financial information stolen from a former employer when they were hacked, and the information was posted on the dark web. She had reviewed all of her credit records for unauthorized activity and placed fraud alerts, but she had not yet been, none of her personal information had yet been used. She filed a lawsuit as a class action on behalf of all employees whose information was compromised, and she only asserted common law claims like negligence, breach of fiduciary duty, and breach of confidence. The complaint alleged injuries of an increased risk of future identity theft, as well as time and money she was going to spend to mitigate the potential harm. The employer moved to dismiss and argued that the risk of future harm was insufficient to establish standing, and the district court agreed and granted the motion, finding that the risk of future harm was too speculative. And even though she had spent money to mitigate the risk by engaging a credit reporting service, that could not confer standing because the risk of harm was too speculative. When it went to the Third Circuit, they reversed and held that the plaintiff did have standing because she had alleged a substantial risk that she'd be harmed in the future as a result of the data breach, and that she had sufficiently established an imminent injury. In coming to its decision, the Third Circuit held several factors should be considered in deciding whether the injury is imminent, and listed these factors as useful guideposts, with no single factor being dispositive to the inquiry about data breaches. And they're listed on the slide: whether the breach was intentional, whether the data was misused, and whether the type of information accessed could be used to commit identity theft. The Third Circuit in this decision specifically addressed TransUnion. They said that its holding was in line with TransUnion because the future harms were in the imminent and substantial category rather than in the speculative category. On the concrete harm requirement for Article 3 standing, the Third Circuit noted that emotional distress from knowledge of the substantial risk of identity theft or the money spent on mitigation measures like credit monitoring services, those are sufficient to establish the concrete harm requirement. Next slide, please. So due to the increased focus on Article 3 standing following TransUnion, we have to be mindful of certain issues. What happens when the defendant prevails on a motion because the plaintiff lacks Article 3 standing in federal court? So when the plaintiff fails to establish Article 3 standing, the courts typically dismiss the complaint without prejudice due to the lack of jurisdiction. So the plaintiffs have the opportunity to refile the case in state court. Winning the Article 3 standing argument doesn't end the matter, and we have to be prepared to litigate all of these federal claims now in state court. The standing requirements in state court are very different. So states can all establish their own standing requirements, and state courts don't necessarily have the same concrete harm requirements as federal courts. The requirements vary drastically from state to state. Only about half of the states apply constitutional standing requirements similar to the federal courts. And of these states, almost everyone recognizes exceptions to its constitutional standing requirements. In many states, the requirement that a party have standing is just a matter of judicial policy, and it's not a constitutional command. So where Texas standing requirements parallel the federal test for Article 3 standing, New Jersey's are the opposite, and standing's not jurisdictional. When faced with a complaint that has a federal claim asserted in state court, defendants typically look at it and often have the option to remove it to federal court. And when we're seeing these now, we see courts basically immediately entering orders right after the removal, directing the defendant to address Article 3 standing, asking whether the complaint alleges concrete particularized injury, in fact, or some other basis sufficient to confer Article 3 standing. And then if the federal court lacks jurisdiction, the case is immediately remanded. We're kind of being faced with a paradox of exclusive state court jurisdiction over certain federal claims. Some states are going to become hotbeds for this type of litigation where they don't have this concrete harm requirement, and others with, standing requirements similar to those in federal court, or Virginia or Mississippi, which don't have state level class action procedures, we're not going to see much action. So this is really interesting, and I love seeing all of the TransUnion motions being brought at all stages of class certification and really all stages in these individual actions. It's a really great option to look through all of your currently pending cases in federal court and see if there is any basis for dismissal at this point, especially in the FDCPA space. Thanks.
Thanks, Kelly. Thanks, Jim. It was a really great and timely summary of Ramirez's impact. Jim, anything else on before we wrap up?
No, I think Kelly summarized it very well. Thanks so much.
It's great.
And obviously, if anyone has any questions, we're happy to take those either now or via email after the presentation today.
Yeah, I also just want to note the CLE code at the bottom. It's your third code, so it's 79325. So please write that down, 79325. All right, well, that will give everybody a couple minutes back in their day today, and this concludes today's webinar. Remember to keep an eye out for the follow-up email, which will include links to the program materials and also a recording and the CLE survey that you have to report back on. If we didn't get to your question, and I think we got most of them, we'll do our best to send a response via email. And in the meantime, feel free to reach out to any of our presenters with any questions. Thanks so much, everybody. Enjoy the rest of your days.